May I please, Your Lordship?
Yes.
I'd like to mention one RSA for listing for hearing in the month of December.
Okay. Take a date for me.
On 19th December.
Your Lordship, with regard to item number 27 and 28, I filed an affidavit with regard to completion of dusty service.
27 and 28.
Yes, Your Lordship.
Okay, call it.
Deeply obliged.
Wait, please, Your Lordship. Lordship, item number 21. My senior, Mr. Arali, is not well, Lordship. Kindly fix it after 2 weeks.
On the pair being made by Miss
J. Gayan.
Learned Counsel appearing on behalf of Mr. R. Ali, Learned Counsel for the appellant. Recessal is the matter on
After
16?
2 weeks, needed.
after 2 weeks. Okay.
After 2 weeks.
May I please? Lordship, we have filed an IA for releasing of safe laws. This matter may come up for orders tomorrow. Obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing a civil division petition matter on 25th of November, Monday.
Under which column?
Motion.
Okay.
May I please, Lordship? Lordship, I beg to mention him, NFA for listing, Lordship. It is a 2017 method, Lordship. Or
When?
hearing. Convenient to take false
Oh, hearing.
hearing, Lordship.
In the month of December.
Then, Lordship, first week of December, Lordship.
On 10th December.
Lordship. Obliged.
May I please, Your Lordship? I'd like to mention for listing of a CRP IO, my Lordship, in orders column.
When?
Next week, any date, my Lordship.
Next week, 27th.
27th. All right, my Lordship.
My lord, item 36, my lord, kindly fixed first week of December, my lord.
36.
Yes, ma'am, supply list. Supply list.
36.
36.
When?
First week of December, ma'am.
Mr. S. R. Sodore, Learned Counsel for the petitioner. Press for listing the matter. The first week of December. Fair alert.
Date, may
6th December.
oblige.
My lord, I beg to mention item 22, Passover for the day. 22.
Mr. A. Pal, Learned Counsel for the appellant. Press for listing the matter. No, press for adjournment. Press for adjournment of the matter for the day. Fair alert.
Let it come on 25, my lord.
Not
Monday?
25th, so many cases. On 29th.
29 with some difficulty. Any day. Yeah, that.
28.
Always.
Yes.
Please, Your Lordship, I want to mention regarding listing of a MAT appeal next Wednesday for admission.
Admission. Wednesday.
May I please, Lordship? I beg to mention in MSc appeal, my lord, for orders under orders column.
When?
Any date, probably on Thursday if it is convenient. The coming Thursday if it is convenient, my lord.
Okay.
Leave development.
May I please, Your Lordship, I'd like to mention for orders of civil revision petition.
When?
29th November.
Lordship, item number 17. So my senior counsel is out of station. Kindly this matter be taken next week.
Who is your senior counsel?
Jubair Ahmed.
Zaid Hamad.
Yes,
Your good name?
Rashmita Rans.
Ms. Also Learned Counsel appearing on behalf of Mr. Zaid Hamad. Learned Counsel for the petitioner. Press for listing the matter. When?
Next week.
Next.
Next week.
Date.
Date.
Next week, date done in the month of December, okay? On 2nd December.
Please, Your Lordship. I beg to mention item number 24, Lordship. This matter may come up on first week of December, Lordship. On 6th, Lordship. On 6th December first.
Your good name?
N. Brahma, Lordship.
Mr. N. Brahmo, Learned Counsel for the council appearing on behalf of.
Petition.
Your name is not there in the item number 24.
Lordship, it's there. N. Brahma.
No, item 24.
Jiva advance.
Your name?
N. Brahma, Lordship.
You are appearing for?
Jiva advance.
G. Verdas, Learned Counsel for the appellant. Recessal is the matter. After 1 week?
Lordship, first week of December, 6th, Lordship.
6th December.
Deeply obliged, Lordship.
May I please, Your Lordship? I'd like to mention RSA number 19 of 15 for listing in hearing
When?
on 3rd December.
Possible.
Hearing in the month of January. In the month of January. December already, Lordship, it is almost full. In the month of January, okay, sir.
December.
12, not 12, 12 is,
In the month of
okay, 12 December.
Previous your lordship, but you will to mention item number 35. I've taken the consent of the other side, lordship. Making the prayer on behalf of my senior Miss R.D. Muzinder.
Pardon?
I'm making this prayer on behalf of my senior Miss R.D. Muzinder, lordship.
Mr. Your good name,
Please, Sharma.
learned counsel appearing on behalf of Ms. R.D. Mazumdar, learned counsel for the petition, appellant with concern from the other side, first for listing the matter. When?
After 2 weeks, lordship.
After 2 weeks. Okay. Fair lord.
May please your lordship. Also, I am praying for listing of this land acquisition appeal lordship in the admission column lordship.
When?
Next week lordship.
In the
After-
first week of December. On 4th December,
This-
4th December.
Lordship, listing for one revision petition, IO 73, 2024, in order column, next week.
In which
29th.
column? In
Order.
which column?
Order.
Order. Okay.
On 29th. Items for motion, item number 1.
On my opinion.
Hmm.
In this case, Miller. The petitioner filed one title suit matter that was transferred to Gwalpara Miller.
Hmm.
And during the pendency of the title suit matter, the opposite party filed 2 petitions matter. One before the family court, one before the CGM matter. One domestic violence, one is the Miller for maintenance Miller. In the domestic violence Miller, this honorable court stayed the proceeding Miller, page 21 Miller. And Miller petitioner before this honorable court for transfer of the maintenance case to Pokraja Miller. Yes, please, John, can you show me?
Now you want to transfer the case from?
From family court to Pokraja. Family court Guwahati to Pokraja. Page 17 Miller.
But one case has been transferred from Kukrazar to Gwalpara.
Gwalpara Miller.
Then
Direct may be possible Miller to Gwalpara, maybe transfer.
let notice go and
Yes.
Heard Mr. A. Mohammed, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure. The petitioner has right for transferring FC within bracket CRL. Case number 234 of 2024 pending before the Court of Learned Principal Judge Family Court Kamrup M. Guwahati to the Court of District Judge Kukrazar. District Judge Kukrazar. First, the petition and the documents placed on record, let notice be issued to the respondents. Respondent returnable in 4 weeks, step be taken by registered post with AD and also by usual process within your from today. Till returnable date. Further proceeding of FC criminal case number 234 of 2024 stands state.
Item number 2.
May please, Lord.
Hmm.
Lordship, I am the defendant here. The plaintiff had filed a suit for recovery of area rent and my eviction from the suit criminal. Now the Munshif has decreed the suit against me. Thereafter on appeal, that was also dismissed on the ground that I am a defaulter. But before that, the learned courts will have made jurisdictional error by not ascertaining the due date. The due date has to be ascertained first in order to come to the finding defaulter. So that is the precise point. And if your lordship sees the plaint, which is at page 16, page 17, paragraph 3. last line. May I read, your lordship?
Hmm.
But the defendant, though early part of his sentence had been maintaining good landlord-tenancy relationship later on, he did not agree to enhance the, no, before that second para. The plaintiff let out the premises, particulars of which is given below in the schedule here too. The defendant at a monthly rent of 3,000 per month, only according to English calendar. Earlier, his father was tenant of the plaintiff, and after his death, the defendant requested the plaintiff to let out the same premises in the year 1999. Since then, he has been occupying the state premises presently at monthly rent of 3,000. The rent is payable on or before first day of each succeeding month. Now, this thing has been given a go by both the plaintiff and the defendant. Now, in my written statement, which is at page 22, para 6, I will read, your lordship. The father of the defendant, late Madan Lal,
Page number?
page number 22,
Hmm.
para 6, last line.
Hmm.
The father of the defendant, late Madan Lal Agarwala, was doing business since 1966 as a tenant of the plaintiff, occupying room in an Assam type house. In 1971, the plaintiff has constructed a RCC building in place of Assam type house, and the defendant occupies the room in the previous place of the ground floor of the building. Later on, another adjoining room was let out. The rent is gradually increased to present sum of 3,000. The defendant begs to state that there is no written tenancy agreement relating to the suit premises, and there is no condition of paying rent on or before first day of each succeeding month. And thereafter, para 8, the same page, the plaintiff did not take rent from the defendant each month, but used to take rent for several months at a time for its own necessity and convenience. The plaintiff took rent for 5 months at a time from September 2013 to January 2014 from the defendant for its own convenience and issued a receipt. So I have annexed the rent receipts also, which your lordship will find starting from page 75. Page 75, the rent receipt of the year 1999. Now that shows that rent has been accepted together for 3 months, rent month of from October to December. Then at the end, page number 113, your lordship will find that rent was accepted in the year 2014 from September 13 to January 14. That is for a period of 5 months altogether. So there is
Whether all these documents are exhibited before the trial court?
That was not exhibited, but the plaintiff has accepted that he has received the notices.
Okay, let notice go at this.
Yes, yes.
Heard Mr. Dr. Learned Counsel for the petitioner. In this petition, under section 115, read section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the judgment and decree dated 29/9/2023, passed by the learned Munship number 2, Lakhimpur, North Lakhimpur, entitled suit number 18 of 2017, whereby the learned Munship has decreed the suit of the plaintiff, and the judgment and decree dated 31/7/2024, passed in title appeal number 12 of 2023, whereby the learned First Appellate Court has upheld the judgment and decree dated 29/9/2023, passed by the learned Munship number 2, North Lakhimpur, entitled suit number 18 of 2017. Where is the petition and the documents placed on record and the impugn judgment and decree dated 31/7/2024, passed by the learned First Appellate Court, and also the judgment and decree dated 29/9/2023, passed by the learned Munship number 2, North Lakhimpur. Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Registrar will call for the record from the learned Courts below. List the matter after 4 weeks. Are there any execution petition file?
No, but there is a prayer in the prayer portion only I have made a prayer for a stay. At page 14.
Okay, interim period of the petitioner will be considered on next day.
Obliged.
Item number 3,
Lordship, the matter may pass it up for the time being. Obliged.
item number 4,
May I please, Lordship? Petitioner is debarred for filing written statement. The impugned order is at page 30. A complete erroneous order has been passed by the
Why?
court below. Can we peruse
Page number?
page number 30? On perusal of the case record, second paragraph, that today is the 85th day after submission of amendment claim by the plaintiffs. The 90th day shall fall on 10/10/2024, which is a holiday, and therefore the petition is rejected. Petition was filed for seeking time to file WS. Section 4 of the Limitation Act provides, Lordship, where the last date is holiday, the next opening day is counted. Section 4 of the Limitation Act. Lordship. Petition was rejected merely because on the day which filed the petition for filing WS seeking time was 85 day,
Hmm.
and the 90 day will be fall
You are referring to section?
section 4 of Limitation Act. When the prescribed
Hmm.
period, where the prescribed period for any suit, appeal, or application expires on the day which the court is closed, the suit, appeal, or application may be instituted, referred, or made on the day when the court reopens.
Hmm.
So this is the ground.
So where is your petition?
Petition is the next page, which is page 31.
Hmm.
For want of some documents, the WS could not be filed on that day.
Today your WS is ready now,
WS is ready almost.
almost.
Ready.
Heard Mr. B. Fukun, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has narrated Section 151 of the Code of Civil Procedure. The petitioner has put to challenge the correctness or otherwise of the order dated 2024 passed by the learned civil judge unit senior division Kamrup Amin Gaon in the title suit number 8 of 2022. It is to be noted here that by the impugned order dated so and so, the learned civil judge senior division Kamrup at Amin Gaon debarred the petitioner from filing written statement in title suit number 8 of 2024 and rejected the petition filed by the petitioner number 3190 of 2024. Mr. Fukun, learned counsel for the petitioner, submits that the petitioner has filed one petition being petition number 3190 of 2024 for extension of time for filing additional written statement. But the learned trial court void impugn order dated 5/10/2024 has held that on that day, 85th day of submission of amended plaint by the plaintiffs, and the 90th day fall on 10/10/2024, which is a holiday, and therefore erroneously rejected the petition filed by the petitioner, ignoring the provision of Section 4 of the Limitation Act, which provides that where the prescribed period for any suit, appeal, or application expires on the day when the court is closed, the suit, appeal, or application may be instituted, preferred, or made on the day when the court reopens. Further, Mr. Fukun submits that the WS in the meantime is ready for filing. Having considered the submission of Mr. Fukun and also considering the facts and circumstances, this court is inclined to allow this petition, as the impugn order dated 5/10/2024 suffers from illegality and also from arbitrariness. And as the same is contrary to the provision of Section 4 of the Limitation Act. It is provided that the petitioner shall submit his written statement within a period of 1 week from today, and thereafter the court shall proceed to dispose of the title suit in accordance with law in terms of at this motion says itself.
Logic, can we 10 days? 1 week, so, okay. Item number 5.
Please, your lordship. The petitioner is aggrieved by the dismissal of his petition which he had filed for amendment of the plaint, my lord.
At what stage you have filed the petition?
My lord.
At what stage you have filed the
At
petition?
the evidence stage. At the evidence stage, because the new cause of action had arisen, my lord, at that point of time, and that is why, my lord, at that point of time, it had required to be filed, my lord. Basically, it was a suit, my lord, where the tenants, my lord, they had surreptitiously, my lord, executed a sale deed, my lord. And the suit was filed.
Where is the impugn order?
At page 137, my lord.
That notice go at this stage.
Notice will go and, my lord, further proceedings are required to be stayed because, my lord, if I am required to, my lord, provide the evidence with these, my lord, defects, then, my lord, ultimately the suit will become bad, my lord. The suit will be, my lord, affected, my lord. That is why it is requirement.
Heard Mr. G. Sodore, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 4/7/2024, passed by the learned civil judge junior division number 1 Sonitpur at Tazpur in Mizji case number 68 of 2021, arising out of title suit number 110 of 2009. It is to be noted here that by the impugn order dated 4/7/2024, the learned trial court has dismissed the petition filed by the petitioner for allowing amendment of the plaint, for incorporating the pairs, for amendment of the plaint to incorporate the subsequent events that has taken place during the pendency of the suit, which was necessary for proper adjudication of the title suit. Peruse the petition and the grounds mentioned therein, and also peruse the impugn order dated 4/7/2022. Let notice be issued to the respondent returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Mr. Sodore, learned counsel for the petitioner, submits that there is a requirement of staying the further proceeding of the case, and unless the same is stayed, the case of the petitioner will be affected. Further, having considered the submission of Mr. Sodore, learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is of the view that a prima facie case for staying the further proceeding of the case is made out, and accordingly it is provided that further proceeding of case number so and so, stands state till next steps. Will return.
Matter number 6.
May it pleases your lordship, lordship can be taken after some time, lordship.
Items for admission.
Let it be at 2 p.m.
2 p.m.
After some time, lordship.
Lordship, otherwise also lordship, here we have to obtain instruction. Here, lordship will find that there is a criteria for duration criteria. The duration criteria is not fulfilled, so we have to obtain instruction also, lordship.
You have to?
Obtain instruction, we have to file affidavit here, lordship. Because lordship, here on the last occasion, there was a direction to obtain instruction for the ACRT, lordship.
In fact, my lord, SCRT has supported this could become an administrative officer, my lord. In that it says page number 34, my lord, what you will see, it was the letter was sent by the director SCRT to the government to consider his case, though he has not fulfilled the mandatory requirement of the period to be as a registrar. So after this letter was this letter dated in page number 33, my lord, 2010-2024. It was sent by the director, my lord, from the director to the government, and the government in next page 35. Since that period has not been fulfilled as a registrar to become administrative officer, government has declined. My lord. Now government had to reply today because of that particular period, as per the rule, that period has not been fulfilled as a registrar, a petitioner, that his promotion to the administrative officer because of his ensuing retirement in the month of December, that has not been considered. Government has declined to entertain that.
No, now the petitioner will be retiring in the month of December.
December.
So,
And they have to fulfill at least.
Mr. Sharma, when
Lordship, may I take a lordship only once to page number 39, lordship. Lordship, 38. Recruitment, clause 6, administrative officer. Recruitment to the post of administrative officer shall be made by the promotion from the select list approved by the commission for the purpose under sub rule 4. from amongst the members of the service holder holding the post of registrar or superintendent in any of the officers for a total period of not less than 5 years on the
Hmm.
first day of year in which the selection is made.
Hmm.
Now, Lordship, may I take your Lordship to the
No, Mr.
recommendation of the
Sharma.
ACRT?
No, Mr. Sharma,
Lordship,
the contention of the petitioner
Lordship.
is that he was not promoted in time.
Yes. That part is to be taken care of by the ACRT, Lordship.
Hmm.
That part is not from the government. Here only that promotion to the post of administrative officer is to be
Hmm.
taken care of by the government. Rest, the
Okay,
promotion is,
you file your
Lordship,
next week,
we will file our affidavit, Lordship.
next week.
Not that clear, my lord. SCRT's name will not be shown, my lord. That is shown in the cost.
In the cost is,
Acha.
my
Sitting
Lordship,
council SCRT.
My lordship, the petitioner was working 28 years as a UDA.
Hmm.
Then he was promoted to the superintendent,
Hmm.
but not in proper due time. And also promoted to the registrar, not in proper due time. If he could have promoted to the post of just higher post in proper time,
Hmm.
then he could have
Okay,
attained the tenure,
what is the date of his retirement?
the 31st December this year, 2024.
Okay, Mr. Sharma, you file a affidavit by Friday.
next, only 10 days time, Lordship, maybe.
No, he
On
would be
31st
retiring.
He is retiring on 31st of December, Lordship.
Maybe.
Under 40 days left.
There are
No,
another
no.
Yes, Lordship, 31st of December. Today it is 28th of November. So he has 40 days in hand. So Lordship will have 10 days time, Lordship, we will file our affidavit.
My lordship, 10 days would be too late. Because he is going to retire on 31st.
Otherwise, we have already.
Okay, next Monday. Heard, Mr.
Being on the bar.
Learned counsel for the petitioner, and Mr. S. Bora, learned standing counsel for the respondent number 4,
SCRT.
and Mr. Sharma, learned standing counsel for the respondent number 1 and 3.
Lordship, respondent number 1 and 3, Lordship.
1 and 3. Mr. Sharma, learned counsel for the respondent number 1 and 3, some step. He will be filing his filing the affidavit in opposition by next Monday. There is accordingly allowed. SSL is the matter on Monday. SSL also reflect the name of standing counsel of SCRT in the cause list.
Lordship, may direct to provide the extra copy.
Receive the extra copy.
Extra copy may be provided by the petitioner.
Yes, lordship, we shall follow.
Okay, today itself.
Today, sir.
Today it's.
Mr. Sharma submits the counsel for the petitioner may be directed to furnish a copy of the petition to him. The learned counsel for the petitioner undertakes to furnish a copy of the petition to Mr. Sharma during the course of the day.
Item number 7 for admission.
My lordship, lordship, the last petition was directed to the restaurant council to submit the activity. The last chance given lordship. Lordship, we have matter lordship. The provincialized lordship. So already once the provincialized school lordship in the year of 2013 lordship, and subsequently that said school has withdrawn this provincialized lordship due to the lack of the dice code not available in lordship. So here lordship, the dice code record is available. Record says lordship. So in the year of 2009 to 10 and 2000.
You are for respondent number
7, lordship.
7.
Lordship, SSF.
You have filed local or no? Sorry, this affidavit in
We
opposition.
need some time, 1 week's time, lordship. Last opposition, need some time to file our affidavit, lordship. The instructions which we have, lordship, we need some further clarification regarding that instructions. That is right. Further 1 week time, lordship.
No, by the order dated 4/11/2024, you have already been granted time.
Yes, sir. One final opportunity, lordship. Humble request.
Thereafter, again, last final opportunity.
No, Lordship. We'll do our absolute best, Lordship. If there's some clarifications, minor clarifications is required. For assistance of the
With
court
problem.
only, Lordship.
Or Mr. Arce does learned counsel for the petitioner.
Acknowledge the council.
And Mr. Your good name?
And we are, Lordship.
M. Boya, learned standing counsel for the respondent number 7. None appears for the respondent number 1 to 6.
Elementary. Elementary.
I am for the elementary Lordship.
1 to 6.
And Mr. Sharma, learned counsel for the respondent number 1 to 6.
Respondent number 1, 2, 3, 4, 5, and 6. 1 to 6 Lordship.
The learned standing counsel for the respondent number 7 submits that he may be granted another opportunity to file the affidavit in opposition. There is allowed recessal list the matter on next Monday.
On 25th.
It is made clear that no further time will be granted to Mr. Boya, learned standing counsel for the respondent number 7.
Lordship, if possible, the cost will be impossible failure, Lordship. The since was long.
Not for this time, next time I will
Yes,
claim.
Lordship. Yes.
You remind this court on that day.
Yes, Lordship.
And number 8.
I'm sorry, Lordship, in the earlier item number 6, the Lordship has fixed on Monday, this Monday or next Monday. Lordship, I have asked to wait for 7 days time, Lordship. Because this Monday.
Next Monday,
Not this month,
coming Monday,
25th.
25th.
Coming month.
May I pray for some account?
no.
Item 8.
Lordship, this matter is pending for last 3.5 years. Not a single affidavit has come from the respondent, Lordship. I am seeking for my appointment as an selected state teacher also. Some other persons also, I have given example, they were given appointment without Lordship. My accumulated mark is much more. But still, I did not get my appointment.
Yes, madam, you are for respondent number,
Ship for SSA responding to,
respondent 2. Have you filed your affidavit?
she was still awaiting our instructions. She may kindly grant us some.
Madam, this is 21 matter. Okay, we will grant you time, but pay some cost.
Ship, my senior may. like,
Pardon?
The matter may be taken up after some time. My senior will come.
Who is your senior?
Mr. P. Nair.
Okay, call him. Wait for some time.
Lordship, in fact, in one similar matter, Lordship, they have filed one affidavit. This matter can also be taken and they may be allowed to file an affidavit.
Let her senior
Oh.
come.
Item 9.
Lordship, may it pleases. The petitioner went on VRS, your Lordship, on 29/2/2016. She applied for VRS and government accepted it. And she went on VRS on 29/2/2016. And Lordship, she was shocked to receive the letter from on 16/6/2020 after a period of 4 years, whereby an amount of, your Lordship, several lakhs, your Lordship, 47,58,174 has been deducted from her account. The contention to respond and that there's an excess drawal. And Lordship, at the face of it, Lordship, may kindly have a look at the Assam Services Pension Rule 1969, my lord. Rule 198(1). At page 251 of this book. 251 of this book. (1969) rule. Assam Services Pension Rule 1969.
You are referring to rule
198(1), my lord. Refund of excess payment, has the lordship got it?
190?
8(1). Topic is refund of excess payment.
Yes.
Lordship, Should the amount of pension granted to an officer be afterwards found to be in excess of the to which he is entitled under the rules, he shall be called upon to refund such excess. For this purpose, the officer concerned shall be served with a notice. Your Lordship may kindly note this part. Be served with a notice by the pension sanctioning authority requiring him to refund the excess payments within a period of 2 months from the date of receipt of him of the notice. On his failure to comply with the notice, the pension sanctioning authority shall order that such excess payment shall be adjusted by short payments of pension in future in one or more installments as the authority may order. Here, Lordship, at the face of it, this order is illegal. Lordship, at Annexure 24 and 22 also, my lord, whereby Lordship is communicated to withdraw. No communication whatsoever, no notice whatsoever to the petitioner.
No, they have already deducted the amount.
Yes, amount your Lordship.
And
can take-
thereafter they have informed you.
Yes, 47,58,174. It's not a small amount, your Lordship. No notice whatsoever. It should be backed by a notice, my lord. And it should be, if anything has to be done, it should be done in installments, my lord. Although government has filed an affidavit, higher authority, I think BTC's affidavit will also be required, your Lordship. And their communication to the effect, there's no fraud or misconception on the part of the petitioner. She drawn the amount, since she's entitled to it, your Lordship. And if any mistake is on their part, my lord, there's no role played by me, my lord.
Who is for the respondents?
For the respondent number 3.
It's for BTC, my lord, and higher authority, they have already filed their affidavit with that effect.
BTC has hardly any role, madam.
BTC. No rule.
Very little role, madam.
Yes, how affidavit from BTC is required?
Lordship, because she worked under BTC, my lord. And the authority who has granted the amount in her favor by the college authorities with the approval of the Boroland Territorial Council. Lordship, all this like Boroma College is within the BTC and the authorities, we have made them as a party as the Director of Education BTC. If they say they have no role to play, then it may be recorded and entire matter may be hard, my lord.
Still we can file, madam. If Lordship permits, we can. 2 weeks time maybe given.
47
No.
lakhs
Are you
deducted from
sure
your
that you
employee,
will
my
be
lord.
filing and the affidavit in opposition? Are you sure?
In deduction, my lord, we have no role, madam. It's the pension department.
But madam, this fund is routed through the
By the government of
BTC.
Assam.
BTC.
To BTC by the government of Assam. BTC don't have independence in finance, right?
Finance, in some cases.
An input letter was by the Director of Higher Education, man.
And who is for higher education department?
Higher Education has already filed their affidavit to that effect. What is the affidavit? Higher Education. 9.
So let us do one thing, madam.
Hello.
We'll fix it for hearing. In the
For admission
meantime,
hearing.
admission
Admission.
hearing. In the meantime, if he want to file affidavit, he can file.
At the face of it, violation of Rule 198(1) of the pension rules, fine. I prefer a short date.
Third Ms. B. Bhuya, learned senior counsel assisted by Ms.
It does.
Ardas, learned counsel for the petitioner. And Mr. S.R. Rava, learned standing counsel for the respondent number 3. And Mr. D. Pomino, learned standing counsel for the higher education department.
Yes, Lord. For 1 and 2, Lordship.
For 1 and 2.
So I am appealing for respondent number 4 on behalf of Mr. S.
And Mr. Your good name?
KK.
Learned counsel for the respondent number 4. Mr. Rabha, learned counsel for the respondent number 3 submits that he will file affidavit here in this petition. Then press for granting in 10 days time. 10 days time here is allowed. Rest is list the matter on
On 13th December.
for admission hearing. In the meantime, Mr. Rabha may file his affidavit in opposition.
If the obliges.
Item number 10.
May I please, your lordship? Lordship, Mr. Khatunier is on legs in court number 17, your lordship. Matter may be taken after some time.
Item number 11. Item 11.
None appears for the petitioner on call. However, Madam Vice Chair, learned standing counsel for respondent number.
All the respondents were.
Oh, all the respondents present. List the matter after 1 week.
Item 12.
Also on 25/7/2024, last subs were given to file affidavit. The
PTC.
PTC authority. And
Yes, sir.
otherwise, Lordship will hear the matter
Today.
as per order. Lordship.
And that's all right, but whether they have filed the affidavit, no. Can we hear the matter without affidavit?
Item 10.
Because if they do not file, it will be next party order.
Item 10. Sorry, 11.
My lord, some of my other colleagues have been entrusted with this matter, my lord.
Yes.
Let me check, my lord.
Who is your other colleague?
My lord.
B. Sodre.
Vikram Chaudhary, my lord.
Whether affidavit was filed?
I have to check, my lord, because
Affidavit has not been filed. Otherwise, it could start to me. Last subs will be given.
Vikram Chaudhary.
Last sons already given. Are you interested to file the affidavit?
My lord,
Otherwise, you will fix the matter for admission hearing.
my lord, if the matter is taken up sometime later, my lord, I can inform you.
Lordship may fix this matter next week. If they file the affidavit, otherwise, Lordship will hear the matter.
Okay.
In exceptional cases, Lordship may fix it.
I will inform him, my lord. Vikram Chaudhary.
We'll fix a date for admission hearing. In the meantime, you can file a affidavit
ma'am.
in opposition. Heard Mr. S.K. Goswami, learned counsel for the petition. Mr. Rava, learned standing counsel for the BTC. Mr. Rava submits that he may be granted some time to file the affidavit in opposition. Prayer is allowed. Lists the matter on
On 16 December.
16 December. In the
Let me look.
meantime,
Lordship may record the earlier order. Otherwise, Lordship, it will not reflect. Last answer was given.
yes. In the meantime, Mr. Rava may file his affidavit in opposition. Otherwise, the court will proceed to hear the matter without the affidavit in opposition filed by the PTC.
Or Lordship, as per order, that will be recorded. Otherwise, it will not.
It is already in the order.
Let's
Okay, but you take down. It is to be noted here that by order dated
25/7.
25/7, last sentence is already given to the respondent. To the standing counsel to the BTC to file affidavit in opposition, and no further sums will be given to him.
Item 14. Sorry, item 13.
May I please, my lord? But the state was supposed to file an affidavit also.
Hmm.
2 weeks time were given, Lordship, as per the last order, Lordship.
Okay, who is for the respondents?
Uh, for 1 and 3, your lordship, the government has to file their affidavit because the impugned order was passed by the government, your lordship. And we were directed to release the ex gratia amount, your lordship. That amount has already been released and the petitioner has received it, your lordship.
Yeah, Lordship.
So when you are going to file affidavit in opposition?
Lordship, lordship, here our role is limited, your lordship, because the impugned order was passed by the government, by the finance department, your lordship. So they'll have to file the affidavit. your
Okay, inform the finance department. Wait for some time.
lordship.
Item 14.
Mr. Nayak was here, again, he has left. 14 again? 14, to exercise time is good.
Okay, kindly pass over for timing, lordship. My senior is the
Who is your senior?
SB Luster, lordship.
Wait for some time.
Item 13, timing, finance.
Babat ko to sir. Item
13 just finance. Item 15. Item 15.
Lordship, here in this matter, Lordship, I see 2 weeks further time, Lordship, to obtain my instruction, Lordship. The matter was last listed on 28th day, on that day they took time. First moved on 19th February, almost a year, my lord. The date may be fixed, my lord, one last chance may be granted, my lord.
Item number 15.
15. It's a
No, it was listed on 28 10.
2810. First moved on 19/2.
Heard Mr. S. Khan, learned counsel for the petitioner, and Mr. D. Pointa, learned standing counsel, higher education department. For respondent number 1 to 3. None appears for the respondent number 4 and 5. Mr. Upamanya, learned standing counsel for the higher education department, praised for granting him further 2 weeks time. Here is allowed for the last time. In the event of failing to file affidavit in opposition on next date, the court will consider to impose costs upon him.
Lordship, in that case, Lordship, can it be 3 weeks, Lordship, because I have to
No,
obtain the
no, no,
instruction?
no. List on, over here, fix it date.
On 13th December.
Lordship, can it be on 18th or 19th?
Okay, 18.
The 13, let it be on 13th, my lord. Lordship, 13th, Lordship, I have some books.
Okay, 18.
Almost a month, my lord.
18.
18th.
Highly obliged, Lordship.
Item 16.
In this
For
case,
finding my senior late, lordship, after some time.
Item 36. Sorry, item 37.
None appears for the petitioner on call, or SSL is the matter after.
I'm for 3 and 4.
You are. How about Mr. Upadhyay and then Upadhyay, learned The counsel for the respondent number 3 and 4 present. This is the matter after 2 weeks. In the event of subsequent non-appearance, non-representation of the petitioner, appropriate orders will follow.
Item 38.
Lordship 38 also typing.
Well, 37, hi, this fellow. My presence will be on the 37.
Okay, later on, Mr. P. Monto, learned counsel for the petitioner present. After 2 weeks.
But there is an order, my lord, on 21/6, my lord. The specific instruction was given to Torville to produce certain things, my lord. In that case,
Nobody is for the finance department.
education department. Torville is for
Education, yes.
education. There is a specific order. Office memorandum, and that is a specific instruction to produce all the
On which date?
on 21/6, my lord. 37. That is passed by Honorable Justice, my lord. You can have one. The next day they should come with all the, my lord, complete information.
But the person concerned remain absent.
Okay, well, then
Probably.
let the matter come after 2 weeks, my lord, or 1 week, my lord. And it is possible when a date may be given because a certain date I will be not available, my lord. On 4th or my lord, no, my lord. Is it possible on 3rd of December, my lord? Must be.
Item 37. For bail hearing. Item number 18.
Lordship, my finger is the next in court number 1. Kindly pass over the matter for time.
Okay,
Highly at 2, Lordship.
At 2 p.m.
at 2 p.m.
Highly available.
Item 19.
Hmm.
Here in this case, the petitioner is in custody for 2 years, 3 months, lordship.
Hmm.
And all the co-accused were granted bail by your lordship, lordship. And lordship may kindly see the FIR page 22. And relevant portion, lordship will find page 26. Page 26.
Hmm.
Possible. May I
Okay.
read, lordship?
But APP is absent. Okay. Itu নহলে তো নহব কাৰণ at what stage the case is pending now?
Evidence is going on, lordship. Total 56 witnesses are there. And out of that, 10 witnesses were examined as per my instruction, lordship. And the other accused were granted bail. And here in the first paragraph.
Before they were granted bail before framing of charge.
Yes, lordship. And
No,
after
no,
framing of after framing of charge also, your
Mr. Ahmed, you see, whenever charge is framed
lordship,
under this 17, 18,
lordship.
19, 20 of the UAP Act. So that 45D has to be complied with.
Yes, that is there, lordship. But what other materials are there, therefore I was trying to place before lordship. When in fact in the first line itself, your lordship will find that he was investigating, the informant was investigating Borpeta PS case number 268 of 2022. In the second line itself is mentioned there. And on the basis of that, he received subsequent some information and he registered the present case. But 268 was already transferred to NIA, Lordship, on 22/3/2022. And this affair was lodged on 28/7/2022. He has no jurisdiction to try that, to investigate the Borpeta PS case 268 of 2022. And NIA Act says, Lordship, that if any further information is received, he has to send it to the government, and government will decide whether it is to be investigated by the police or the NIA, Lordship.
Is there any requirement
That section 6 is there, Lordship.
of NI Act?
Right. Already this case was transferred to NIA. He cannot investigate that offense. And if subsequent information is received, he has to transfer it to the government or the investigating officer of that case. He cannot register a subsequent FIR for that.
No. When he registered the FIR, before transferring the case to the NIA?
Yes, after handing over to after 4 months of handing over the case. Lordship.
To NIA, he has registered this case.
Yes, subsequently he registered this case. In the month of, Lordship,
NIA.
22 March 2022, that case was transferred to the NIA, Lordship. And he registered the present case on 28/7/2022, after 4 months. Section 6, Lordship, may I kindly see.
Section 6.
Lordship.
But while dealing with a bail application, should we consider all these matters? Had it been a petition under this earlier 482, then the matter would have been different.
That I understand, Lordship.
Yes.
That I understand. But your Lordship can consider, because he is already in custody for 2 years, 3 months. And the case which was transferred to NIA, he was already, Lordship, sentenced to that period undergone, and he was, Lordship, released from that case.
He admitted guilt.
No, Lordship. Even in fact, if I may take your Lordship to that order, Lordship will find page 83. Lordship, may I kindly see one line, just I am not reading the entire, although I have not challenged, but page 89 of my petition, Lordship, may I kindly see that order I have enclosed, on what basis he is convicted.
89.
Paragraph 15, Lordship, may I kindly see.
Paragraph
15.
Yes.
From the above, may I read? It can be seen that neither of the two convicts are accused of being involved in any violent act. Their involvement is limited to being members of a prescribed organization, and it appears that they were involved in providing logistical support to A1 for raising the ABT AQIS module and for inviting support from the module. Out of the 8 PWs examined so far, none has implicated A10 and A11 in any manner. Even then, they were convicted for the period undergone. So I am not disputing those things at this stage.
Let APT come. Wait for some time. Mr. Goswami.
Sorry, Lordship, I was on next slide.
So you were the only APP in the court? So whether this case was allotted to you?
Item 19.
Person may kindly allow me some time to just go to the scan copy zone. Go through it now.
You have not answered my question, whether you have been allotted to deal with these cases in this court today.
Yes, ma'am. In several courts, in other court also allowed just as a motion court, madam, that since I am appearing there, madam, I could not appear here, madam. That is my answer.
Okay, Mr. Ahmed at 2 p.m. then.
Lordship.
Okay.
39.
Madam, 4 years, 3 months. This petitioner is in custody, my lord. 4 years, 3 months and 9 days to be precise, my lord. My lord, the petitioner.
Actually, deposition of witnesses are not there in the record, Lordship. That is necessary, Lordship. Deposition of witnesses, Lordship.
Whether same were called for,
Yes, Lordship. Case record was called for.
whether case record was received.
Received, but deposition of witnesses are not there, Lordship.
My lord, in my respectful submission, my lord, subject to what your lordship says, my lord, here it is purely the case is based on length of detention, my lord. As far as the depositions, my lord, 2 out of 8 witnesses have been examined, my lord. My lord, I'll just take your lordships to 2 orders passed by your lordship in this case, my lord.
No, now how many witnesses have been examined?
3 witnesses has been examined out of 11 witnesses. There are 2 orders from your lordship directing them in 2022 to resort to 309. They did not do it. In 2024, your lordship again directed that resort to 309. Your lordship has even observed that you are violating their fundamental right under Article 21. I'll take your lordship. It is your lordship's order, my lord. Your lordship may kindly see these 2 orders. One was passed in 16/12/2022, the first one. This is for the co-accused, same case. Now, my lord, while rejecting this bail application on 16/12/2022, my lord may kindly come to paragraph 13, that is the last paragraph.
Yes.
My lord, see, accordingly, the instant petition stand dismissed. However, the learned court below is directed to expedite the trial and complete the same at the earliest possible time without being influenced by any of the observation made herein above, as the same is made only for the purpose of disposing this bail application, not merit of the case. And if necessary, recourse has to be taken to the provision of 3091 CRPC. When they did not adhere to this judgment, to this order, my lord, we filed another bail application before your lordship. There is the second bail application, my lord will kindly see. This was in the year 13/2/2020. For the co-accused who happens to be the...
Okay. Where is Mr. Kyle?
He is in Lexington Court number 1, Lordship.
Let him come.
He will come at 2, Lordship, along with other men.
Okay, at 2 p.m. You are behind the bar for 4 years.
4 years, 2 months, and the co-accused whose bail was rejected by this order has been granted bail by the Honorable Supreme Court.
Item 40.
I give this.
Yes, Your Lordship.
Yes.
Substituted matter, the scanned copies of the proceedings were called for evidence. Probably it has been received. Scanned copies were called for.
Madam, has been received, madam.
In fact, the deposition of almost all the prosecution witnesses have been completed. One remains, that is what we have been instructed.
With your lordship's permission, my lord, can it be taken up along with this item at second half, my lord?
So your contention is that section 51 of the NDPS Act has not been complied.
Yes, and PW1, who was the person, the SI of the police station, who conducted the search at that point of time and also arrested him and recovered the gun. His evidence clearly does not say that there was he was informed, the accused was informed that he has a right to be searched before taken before the magistrate and searched. 50 is clearly violated here.
50 or 51?
50. 50.
not
Written
51.
notice is not required, but he has to be informed that he has a right to be, the search, he has a right to be taken to the magistrate before the magistrate, and his search can be conducted there. And there is nowhere there in none of the prosecution witness. In fact, this witness, he does not say that he was informed, the accused was informed regarding that. And also the other prosecution witness does not implicate him at all.
Whether the requirement of section 51A has been fulfilled or not.
51A.
NDPS Act.
Lordship 51. Subsection 1. Wherein the officer duly authorized under section 42 is about to search any person under the provisions of section 41, 42, or 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the department mentioned in section 42 or to the nearest magistrate.
No, the section I am referring to is 52A, not 51.
52A.
52A. This
I understand.
drawing of sample.
Yes, yes.
And preparation of this.
That will come later. First of all, the search aspect that, first of all, that search recovery of contraband, that aspect has to be seen first, because that will come later, drawing of samples and other things. Magistrate's order and all of that will come later on, after the recovery is made. 52. With due, first of all, 50 has to be complied. And Lordship, the Constitution Bench in Valdev Singh has clearly laid down that if the accused has not been informed, in fact, the whole search stands vitiated.
No, that's all right. Yeah, but whether we can deal with that issue at the time of consideration of bail or not.
Yes, Lordship. Consideration of bail, had the charge sheet not been filed, probably that would have been a different matter altogether. But here is a case where the trial is almost completed, and the the deposition of the prosecution witness, evidence of the prosecution witness, clearly lays it's action from that that 50 has been violated. The initial point. Only when the search is made and the recovery is made, only then the accused is implicated. And that point, that is why 50 has been inserted. So that unnecessarily an accused cannot be given stringent punishment. That is what the...
Madam, my question is whether at this stage, we can consider compliance or non-compliance of section 50 or not.
In my humble submission, yes, because as I had submitted, the trial is almost completed.
No,
we have the
Baldev Singh, in the case of Baldev Singh, Supreme Court has stated otherwise. That can be considered at the stage of trial.
At the stage of trial.
That observation is there.
Yes. But here...
While dealing with bail application, can we consider the same? That is my question.
Why I'm saying yes, because here is a case, Lordship. If the accused has a chance of being considering the deposition of the prosecution witnesses, evidence of the prosecution witness, if there is a probability, there is the accused stands a chance
might
of
be
being
acquitted.
acquitted.
No, that's all right. My question is, can we consider that aspect? Well, the Supreme Court has stated that constitutional bench has stated that it can be considered only at the stage of trial.
Yes, trial that is.
Therefore,
yes.
I am asking you whether there is compliance of 52A or not.
52A.
Yes.
52A, probably if I go through the entire records, there are 52.
You can go.
I have to go to...
okay, at 2 p.m. then let him also go to the record.
What I, Lordship's query, madam, what I like to submit, madam. As per my linear learned senior has also said, the trial is almost completed, my lord.
Mm.
At this stage, my lord, appreciating the evidence may, my lord,
No, you're not.
appearing
It
on
will
the,
not form
if my lord, and she has no case regarding 52A, regarding sample. Only expect that only 50 is my lord violated. So at this stage, my lord, still, pray that it may not interfere. my
Let
lord.
us take it up at 2 o'clock. In the
Yes.
meantime, madam, you go through the Baldev Singh's judgment.
Yes,
Yes.
Baldev Singh lordship is clear. Yes,
Hmm.
at the time of trial, initial stage, what I was trying to submit is that probably if the charge sheet has not been filed and the trial had not commenced, at that point of time, yes, 50, whether there is compliance of 50 or not, probably in a bail application that cannot be gone through. But here is a case where the trial is going on
Mm.
and the accused is facing trial while being under custody.
Mm.
And as the law prescribes that he has a chance, he has a scope to make an application for being enlarged on bail. Considering the fact that trial is going on and we have the evidence of the majority of the prosecution witness, that can be gone through. Baldev Singh, on that point, Baldev Singh should be probably interpreted in that manner. That is what my humble submission is, Lordship.
No, that's all right, but whether it is open for interpretation in that way or not, that has to be
Lordship,
seen,
yet,
because it
let-
was a decision of constitutional bench.
I understand.
So, let him also go through the record. We will take it up 2 o'clock.
Even I'll go through. So whether there is compliance of 52A or not, whether that will be required, because 50 is the first step, and after that it will
So
52 will come.
52A is another requirement.
Yes, that is
And
another requirement,
there
yes.
is a observation of Supreme Court that non-compliance of
Yeah, 52A is also
yes,
vitiates the entire
trial,
yes.
entire proceeding. That's why I'm asking you to go through this.
I'll go through it. Yes.
Item number 20.
FI is 17, if I. FI that is 17, my lord. With due respect, I beg to signature one. my lord. As for FI, my lord, there is no person for FOXO attracted, my lord, or 376 not attracted, my lord. Also, can we see page?
No, case is registered under the POXO Act.
FOXO, my lord.
So we have to comply with this
Notice person.
service of notice. What
Yes,
happened?
Yes, sir. Today it is for service report, my lord. I will go through if any report is there,
Pardon?
if any report is there in the file, I have not taken, but whether in the office.
No,
also-
there was a direction to produce the report.
Yes.
By the additional PP.
Yes.
You produce the report.
Yes. I'll go through the office, whether it is.
Okay, at 2 o'clock.
Yes.
Items for hearing under order 41, rules of CPC. Item number 23.
Passport for timing. 10 case of oil, I will. That too.
Okay.
Item 25.
Then I guess for the appellant on phone, SSL is the matter after 2 weeks. Probably. Second, substance and poison. It will be record for not possible. None appears for the appellant on call, recessal is the matter after 2 weeks. In the event of subsequent non-appearance, appropriate order shall follow.
26.
Yeah, please. My lord, this is a transfer petition, my lord. My lord, the ESD, my lord.
Transfer
From Bilasipara to Guwahati, my lord. The respondent, he, my lord, himself also filed a case before this CGM
Kamrup.
Yes. Complaint case, my lord, 484 of 2024, at page 19.
Page?
Page 90.
Madam, have you filed any objection here?
Lordship.
You have objection?
No objection, we will file objection, Lordship. 2
We
weeks
have
time-
not yet filed.
Not filed. We have entrance appearance for the first time, Lordship.
So the petitioner is staying at which place? Guwahati?
Guwahati.
And the respondent?
Respondent, he filed a, my lord, TSR, my lord, a title suit for restoration of conjugal rights at Bilasipara, my lord.
He is practicing lawyer in Bilasipara.
He is also a practicing lawyer in Guwahati also. My lord. He has permanent accommodation at Hattigaon. His I-card, my lord, all have been annexed to me. So, my lord, he himself filed a case before the CGM Kamrup.
At what stage that case is pending?
Yes, my lord.
At what stage it is pending?
That is, my lord, appearance, my lord. Already appeared, my lord. Copy has been served, and my lord, the opposite party also appeared.
So let both the cases be tried in Guwahati. Why you are objecting?
Lordship, we file our objection, Lordship, 2 weeks time may be pending. Let our stand be brought on record, Lordship.
This proceeding is stayed here.
Yes.
Heard Mr. S.A. Ahmed, learned counsel for the petitioner, and also heard Miss
F Intaz.
F.A.
F Intaz, Lordship.
F. Intaz, learned counsel for the respondent. The learned counsel for the respondent submits that she may be granted 2 weeks time to file objection. There is allowed, list the matter on
9 December.
9th of December.
Lord, interim order passed.
Till then, interim order pass earlier shall continue.
Oblige.
27 and 28.
I then again.
27 and 28. Will put name.
May I please, Lordship? This matter, I have a small submission, Lordship. Lordship, kindly turn to that order dated 5/11/2024. In this, on that day, we have submitted that we had filed our wakalatnama only in transfer petition. But today it is shown in the CRP 104. But we have no instruction to appear in this matter. And from the office note, it is seen that service is also not completed or not award for service report upon all the respondent.
No, if you have not filed Okalat number, you have no right to appear before this court today.
Yes, Lordship.
Okay.
All of them have been served, my lord, by Dusty, all the parties. So this coming and saying I have to appear in this and that is going on for quite some time. Matter may be heard. Once they have been served with the petition, all details are mentioned in the petition. They do not want to appear, that's their headache. Counsels are here present in the court. And though it was not necessary to adjourn the matter, because in the transfer petition itself, all the details are mentioned. Still, your lordship was of the view, one fair chance should be given to them. We undertook that they will be served by the seat. We have done that also. No, I leave it. Because they are holding on to the illegal capture of a portion of the airport land. They're free of cost, sitting there comfortably and bargaining with the government, taking huge amounts of a property which they have trespassed into. This is the whole thing. That's why they don't want to come. This is the reason why we got this transfer. And the order of the Honorable Chief Justice clarifying everything that was read out to them, they are aware of it. So they could have notified that this is the portion. So in spite of that, if they don't want to appear, I leave it to your lordship. Cannot go on.
Heard Mr. K. N. Balagopal, learned Advocate General for the State of Nagaland, assisted by Ms. M. Casey, learned Additional Advocate General for the State of Nagaland, for the petitioner. None appears for the respondent on call. Mr. Balgopal, learned Advocate General, submits that person to order dated.
Your lordship is saying none appears, whether service is complete.
Yes.
I could not see that.
We have filed the affidavit.
Affidavit has been filed.
Then if your lordship see, your lordship can see 18/11/2024.
No, today morning, they have submitted that an affidavit has been filed and prayed for calling the affidavit from the section, and accordingly, we have called the affidavit from the section, and it appears that service has been effected upon all the respondents by Dastemut.
Your lordship kindly see, the notice has been issued by registered as well as Dusty service, and service report is awaited. Stressed by.
Mr. Datta.
Yes.
What I have stated earlier, you have not listened it.
I have just come. I haven't heard anything. I have
Just
come.
now I have stated.
Your lordship has said none appears.
Yes.
Now how?
No, I have stated that they have filed an affidavit after Dusty service.
Correct.
Today morning they have mentioned it.
Now this is today is for service report.
Yes.
If it is service is completed.
Yes.
Your lordship will fix a date. That's the usual process, if I understand correctly. I have been in this profession for last 42 years, and I know that's the procedure.
Yes.
So therefore, your lordship will fix a date.
So none appears today.
It's all right.
What I have what I have dictated.
My lord, your lordship can listen.
Go ahead.
We are discharging our duty. Your lordship is discharging your duty.
I am
Therefore,
not.
there should not be all these things here.
No.
We must cooperate. There must be cooperation between the bench and the bar.
Definitely.
So why we take personally all these things?
Pardon?
Why we should take personally everything?
No.
Something that we are avoiding. Why your lordship will accept it as a gospel truth?
This
there
affidavit,
is a system, there is a procedure.
Why should I disbelieve this affidavit?
I'm not saying that. Your lordship, obviously your lordship will believe it. But then after this, what your lordship will do? Your lordship will fix the date.
Definitely, I will fix it. Definitely.
That is what I'm saying.
Definitely, I will fix it.
Have I said any other thing? Have I said any other thing? Your lordship tell me.
No.
So your lordship will fix a date. A date will be fixed.
No. I have not completed the order.
All right, then your lordship complete.
You sit down, please.
Your lordship,
please sit
your
down.
lordship should not say that.
No, please sit down.
I know what I have to do.
Let me complete an affidavit has been filed today to the effect that service upon respondent number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, and 15 have been effected by Dastemut. And an affidavit to that effect has also been filed today. And perusal of the affidavit indicates that service upon respondent number 1 to 15 have been effected, but none appears for the respondent on today. So list the matter after fix it.
Even that suggestion.
Should it be on 7th December? 7th December, if it is on.
7 December, Saturday. On 9 December.
96.
Eh?
96.
Not 9, 10, 11, 12. No, this we have matter.
On 6 December.
Or we can keep it on 13th or 14th.
13.
1-3.
Okay.
13 is Saturday.
I'm told 13th and 14th, Saturday, Sunday, keep it on 15th.
That's 28 was item 28.
Pardon?
28.
15 is okay, no? 13th is Friday, I believe, no?
Then which date will be preferable to you? Which date?
13th.
13th?
Yes.
Okay.
28.
May I, your lordship? Lordship, the affidavit was filed yesterday, not today. Those affidavits which have come on record, it is.
I filed yesterday, Ajit Corporates.
Okay.
In both the cases.
Yesterday.
28 affidavit.
Same order in 28 also.
Yeah, please, the Lordship. Lordship, we have filed a dusty compliance.
106.
We have filed a dusty completion affidavit.
Yes.
Today on.
Yes.
On behalf of 1 and 6, others we could not complete.
That I am paying for 1 and 6, respondent number 1 and 6.
You were applying for 1 and 6.
Yes.
And upon the rest of the respondent, notice could not be served. Dusty was permitted upon all the respondents?
Yes, Lordship. We could not make service to other parties.
Okay. Heard, Mr.
Amen.
Learned counsel for the petitioner. Then Mr.
S. Afridi.
S. Afridi, learned counsel for the respondent number 1 and
6.
1 and 6. The learned counsel for the petitioner submits that though void order dated 13/11/2024, the petitioner was permitted to to effect service of notice upon all the respondents by dusty mode, yet they could effect service of notice upon respondent number 1 and 6 only. And that's for time, 1 week?
1 week.
1 week time to effect service of notice upon remaining
2 weeks time
respondents.
may be given. In the 2 weeks time may be given. In the meantime, we will file our affidavit in opposition.
There was some urgency perhaps.
Yes, Lordship.
Actually, in the pleadings only, they have conflicting statements. They are giving conflicting statements and everything. In their pleading, they have said that we did not get any decree for recovery of possession. Whereas in the decree, it is clearly stated that we can get they are entitled to get the khas possession of the same. So they are giving such statements, and now they are
So
saying
10 days time? 10 days?
Okay.
Service within a period of 10 days. There is allowed. In the meantime, the learned counsel for the respondent number 1 and 6 may file objection if so advised.
Item 30.
Please, Lordship, we condone the delegation of time, Lordship, to notice may kindly be issued, Lordship, 15 days.
For Mr. Agarwala, learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 52 days in preparing MSc appeal, connected MSc appeal
MSc case number,
against the
MSc case number, Lordship, 775 only.
Mr. Agarwal, I am dictating the order.
Oh, Lord.
It is desirable that you don't disturb at the
Sorry,
time of
Lordship.
dictation.
Sorry, Lordship.
কি করলো? Connected appeal against the judgment and award passed by the learned Motor Accident Claim Tribunal number 3, Kamrup M. Guwahati in MSc case number 775 of 2070. Let notice be so to the respondent. Stroke opposite party. Returnable in 4 weeks. Submit taken by registered post with AD and also by usual process within a week today. List the matter after 4 weeks.
31.
May I please, this appeal is listed first to the lecture. There is an I for delay continuing for a period of 7 days. Lecture.
For a period of
7 days. Lecture.
7 days. Let notice go. Third, Mr. Your good name? Ekakote, learned counsel for the appellant. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 7 days in preferring appeal against the judgment and award dated 38/7/2024 passed by the learned member MSCT Motor Accident Claim Tribunal number 1, Kamrup M. Guwahati in MSc case number 834 of 2016. Let notice be issued to the respondent. Returnable in 4 weeks, the bid taken by registered post with AD and also by result process within a week from today.
32.
May it please, your Lordship. My Lord, I am the defendant, the appellant herein. Miss case 3481 is there for the first time. There is a delay of 109 days in the regular second appeal. I have given my reasons at para 4.
Let notice go.
Though I am not entitled, but can I make a small prayer? Yes, their execution case has already started. But
Sorted then. We will permit you to cause service of notice by dusty mode also.
dusty will not be possible because it is Karbi Anglong, madam. We will go from here. Well, the problem is, let it be on speed post if it's possible.
For speed post, perhaps a permission is not required from the court.
But otherwise, it is not in the Guwahati High Court rules that speed post can be given. There should be a specific judicial order.
For Mr. P.K. Roy Sotori, learned counsel for the applicant. This application under Order 41, Rule 3A of the Code of Civil Procedure is preferred for condonation of delay of 109 days in filing regular second appeal, connected to regular second appeal. Where is the petition and the documents plus on record? Let notice be issued to the respondent, returnable in 3 weeks. Returnable in 3 weeks. Submit taken by registered post with AD. Within bracket, the registered post with AD and also by usual process. Speed post is also permitted. Service of notice by speed post is also permitted. This is the matter after 3 weeks.
Item 33,
By legal lordship. Lordship, this is a section 5 application along with the civil revision petition. My lord. There has been a delay of 208 days on preparation. My lord, the connected petition is under section 115 against the impugn order is of 13 December 2023, passed in an execution case, my lord, whereby my execution petition was dismissed. As such, this section 5 petition under section 115.
That notice go and does.
Yes, ma'am.
For Mr. K.R. Borgo, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 is prepared by the applicant for condonation of delay of 208 days in preferring connected civil revision petition. That notice be issued to the respondents, returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
34,
There is an IA for containing delay period for a period of 24 days. The matter is listed first today.
Heard, Mr.
एक आपत्ति
Learned counsel for the applicant. This application under section 5 of the Limitation Act, read with section 173 of the MB Act, is prepared by the applicant for condonation of delay of 24 days in preparing connected MSC appeal against the judgment and award dated 3/7/2024 passed by the learned member MSCT number 2 Kamrup and Guwahati in MSC case number 1107 of 2017. Let notice be issued to the respondents, returnable in 4 weeks. That be taken by.
MSCT number 1 words. MSCT number 1 words.
But what you have mentioned in your petition? Page number 2.
It was wrongly.
Huh?
It was wrongly mentioned. Also.
Wrongly mentioned. You file an application then
That's it.
for making necessary correction. Returnable in 4 weeks. So before taking a step, you file a application for correction of the MSCT number 2 as MSCT number 1.
41,
Yes.
item 41.
May I please proceed? We have filed of affidavit of opposition.
Applicant absent.
They have a delay of 13 days.
13 days. None appears for the applicant on call.
Item 41.
Lord, there is a delay of 13 days in filing this review application. Your lordship will find the delay has been explained in para. in paragraph below 3. In IA application 3153. In the process, my lord, there is a delay of 13 days that we have explained in paragraph 9. Now, respondent filed their objection. In your lordship, look at their objection at paragraph 6.
Paragraph 6, we have stated, my lord.
They want to say there is a delay of 43 days. That position is not correct because, my lord, review application is required to be filed within 30 days. So the 30 days deduction they did not make. And therefore, according to them, delay is 43 days. That is not correct. In fact, my lord, delay is only 13 days, and possibly, my lord, your lordship may condone that and fix a date for admission.
Yes.
Oh, submission may be recorded, my lord, the, extra one, my lord. Please,
The next are one of your affidavit.
my lord, in IA, my lord.
Yes.
There, I am, my lord. They have, my lord, received certified copy of this honorable court order, my lord, 28/2024, my lord. 19/8/2024, my lord, order, my lord. 20, they received on, my lord, 28/2024, my lord. That's, my lord, 43 days, my lord. My lord, our submission may be recorded, my lord.
42 days.
43 days.
Heard Mr. S. Dotto, learned counsel for the learned senior counsel assisted by Mr. S. Dotto, learned counsel for the applicant. And also heard Mr.
HB new.
SP
New.
now learned counsel for the respondent. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 13 days in preferring first appeal. This first appeal or review petition?
My lord, review petition. My lord, that contention is wrong, my lord. The last occasion also, the lordship has shown me that that was a mistake, but is a review petition, my lord.
In preferring connected review petition against the review petition of the order dated 19/8/2024 passed by this court is CRP IO number 306 of 2024. Mr. Dotto, learned senior counsel for the applicant, submits that the ground of delay has been stated in paragraph number 9,
Yes.
9 of the interlocutory application. And it is stated that while the order was passed on 19/8/2024 in CRP IO 306 of 2024, the certified copy of the order was obtained on
28. This 22/8.
22/8/2024, and that the delay is not deliberate and intentional, but the same is circumstantial, and therefore it is contended to condemn the same. On the other hand, learned counsel for the respondent, opposite party, submits that there is delay of 42 days in preferring the connected review petition, and that he has objection in condoning the delay. But having heard the submission of learned advocates of both the parties, I have carefully gone to the petition and the documents placed on record. And I find that delay of 13 days is sufficiently explained in the paragraph number statement and averment made in the paragraph number 9 of the application. And having considered above, and also considering the given facts and circumstances on the record, this court is inclined to condone the delay of 13 days in preferring the connected review petition. In terms of above, this I stands closed. Now the registry will proceed to register the review petition and place the same before the court as soon as practicable.
Much obliged.
Timing matters. Timing matter item number 13.
Lordship, in this matter, I am appearing for Finance Department, Lordship. So for a stand of the Finance Department is concerned, Lordship, it is there in the petition also, Lordship, at page number 66. It was rejected because of the ground that it reached Finance Department 19 years after the date of the person concerned, Lordship. So that is one ground, Lordship. And secondly, Lordship, it was applied after 3 months, Lordship. He should have applied prior to 3 months, Lordship. I mean, before the expiry of 3 months. So if Lordship permits me, Lordship, I can file one affidavit, Lordship.
When?
Lordship will grant me 3 weeks time, Lordship. I have not received any instruction, but order is there, Lordship. I will definitely obtain the instruction and file a necessary affidavit.
Okay.
3 weeks.
Heard, Mr.
M. Brahma.
And Brahma?
Lordship, one small summation. I have made my application within the time, Lordship. And that was supposed to be considered and which was not considered. And later on, the Honorable Court has said to consider the application, Lordship. So therefore, it was on time. So there was no lapse on my part.
Learned counsel for the petitioner. And also heard, Mr. Your good name, please?
I am P. Nayak, Lordship.
P. Nayak.
Finance Department.
Learned standing counsel for the Finance Department. Mr. Nayak submits that he may be granted 3 weeks time to file objection in this petition. Here is allowed. This is the matter after 3 weeks. Or should we fix it that
On 18th December.
18th?
18th
December.
December. Timing item 8.
In this matter, basic grievance of the petitioner is that the ground on which her candidature was rejected, on the basis of same ground, the private respondent's case should also have been rejected, Lordship. Lordship, on the basis of the grievance in the petition, Lordship, department, I mean, I am representing SSA, department conducted an inquiry and found that, in fact, they have been wrongly selected, Lordship. But in the meantime, Lordship, they have resigned from their post, Lordship. Now they are no more in the post to which they were selected, Lordship. So that is the stand, Lordship.
Lordship, this is a verbal submission. Let them
file an affidavit by making this stand clear also, so that I can make my reply.
Okay, file your
My
affidavit.
prayer is not for lordship cancelling their appointment, lordship. I am seeking my own appointment.
Here, lordship, prayer, basically, on as you have selected them, you should select me also. That is their prayer, Lord. But we found in our inquiry that their selection of the private respondents was not as per rule, lordship. And in the meantime, they have resigned and they are no more in their in the post to which they were selected. I will file an affidavit also.
Okay, when?
3 weeks, lordship.
Okay, third Mr.
SK Das.
SK Das, learned counsel for the petitioner. And also heard Mr. Nayak, learned standing counsel for respondent number
SSA law.
for the SSA. Mr. Nayak submits that he may be granted 2 weeks time.
Lordship, I kindly make it 3 weeks.
3 weeks time to file
Last 3.5
affidavit.
years, lordship is pending. Last 3.5 years, lordship, the matter is pending. No affidavit. That is why, lordship, in the morning, lordship, you wanted to impose cost.
This matter has already become infructuous in fact.
How can it be?
It has already become infructuous.
Without filing an affidavit,
Whatever.
after they say it can become.
Lordship, I will file, lordship will grant me 3 weeks time. Lord.
However, it appears from the record that sufficient opportunities were afforded to Mr. Nayak to file the affidavit in opposition. And having considered above, Mr. Nayak is granted only 2 weeks time. In the event of filing to file affidavit on next date, the court will consider imposing cost.
Lordship, this matter may be taken with along with another analogous matter, lordship. It is also pending. WPC 1449 of 2021.
The learned counsel for the petitioner submits that in connection with same subject matter, another rate petition is pending before this court being WPC number
1449 of 2021.
and praise for listing the matter and accordingly contended to take this matter along with that rate petition. Rest shall do the needful in this regard.
Outline.
Priming item 10. Finance. Bill.
But I have obtained instruction as regards the cabinet decision, whether the review decision was placed before the cabinet or not. It was not placed before the cabinet, madam. The subsequent review decision taken by the under the chairmanship of Honorable CM that has not been placed before the cabinet.
Then what would be the consequence?
But the earlier decision was taken by the cabinet, madam. And it was reviewed by in a review meeting, which has not been placed before the cabinet.
So review meeting cannot
Override
the cabinet decision.
Legal position is clear on otherwise.
Have you filed affidavit?
I have filed affidavit. In fact, I have filed 3 affidavits, madam. Verifying our stand in subsequent affidavit. In the initial affidavit, we have said nothing, madam, but subsequently we have filed 2 affidavits enclosing the cabinet memorandum as well as the review decision, madam. Can be my first additional affidavit, madam. one affidavit I have filed on 27/5/2024. The other one I have filed on 13/5/2024.
So all the parties are before the court,
Yes, my lord.
then we can fix a date for hearing.
Yes, my lord.
Or you are ready today for hearing?
My lord, I am ready. Otherwise, the matter is simple, my lord. My only prayer is that I have been denied from the benefit of the cabinet decision, my lord, which has been given to the teaching staff, and we are denied. This much, my lord.
Well, I am representing secondary education department, and I can represent elementary also. My lord. Finance is also a party. And in fact, I have filed the affidavit on behalf of Managing Director Adarsh Vidyalaya. So that I can represent, my lord. So my lord may fix for a hearing day, my lord. Only issue to be decided whether decision can be override by a
Review meeting.
Yes, my lord. That is the only point to be decided, my lord. Otherwise, facts are very simple.
Tomorrow?
Tomorrow, my lord, I have another part of that code too, my lord. So can it be, my lord? Next Wednesday, my lord. Next Tuesday, my lord.
26th November. Yes, sir.
Okay.
26.
Or Mr. S. Alim, learned counsel for the petitioner, and Mr. N.J. Khatonier, learned standing counsel for the respondent, secondary education department. List the matter on 26 November for hearing, admission hearing. On that day, an effort will be made to finally hear and dispose of this petition.
Pending item 14.
Non-appeals for the petitioner on call. It will be evening. 2 PM for their one. Okay, at 2 PM then.
Lordship, in this matter, B. Chaudhary appears, he's the standing counsel for SSA.
Yes.
Lordship is unwell today, so he's not in court. Should we take up the matter?
He is absent today. None appears for the petitioner on call. To I would have done call for him. Call for his phone license. Phone appears.
I'm not his name.
Okay, on the pair being made by Miss
H. Barwa.
H.
Barwa.
Barwa, learned counsel. Appearing on behalf of Mr. B. Chaudhary. B. Chaudhary.
B. Chaudhary.
Chaudhary. Learned standing counsel for the SSA. Recessal list the matter after 2 weeks.
Pending matter 16.
My lord, day before yesterday, your lordship was asked to obtain instruction as to whether under which provision lordship the joint committee has been constituted. Page 62. Your lordship was directed to.
Yes, Mr. Talukdar.
My lord, I have received the instruction. There is a notification dated 5th August 2022. It constitute a committee, my lord. And earlier also constitute a joint committee, my lord. Regarding the any dispute, my lord. So if FLC and DLC are not satisfied, my lord, then they have placed before the joint committee. Accordingly, joint committee has submitted their report. And his case is, my lord, pending before the joint committee, my lord. So
Oh, whether in the act any
Act does
provision
not-
for
no,
constitution of
act-
joint committee,
There is no provision for, in the act, my lord, there is no provision for.
then unless there is sanction of the law, how can you constitute this joint committee?
So at this time, my lord, my humble prayer, lordship may wait for some time to outcome of the joint committee, or lordship may dispose of the matter directing the respondent. He also made party in the joint committee, my lord. So as early as possible, if we consider, my lord, as, because there is no doubt about, my lord, regarding the provincial, because I have also received another instruction, my lord, from the director, my lord, that the director has verified all the things and placed before the government to provincialize his service, my lord. So lordship made
So proposal is pending,
my lord, proposal is pending before the joint committee. my lord.
joint committee.
So lordship may either wait for some time or lordship may direct the.
Wait for some time means how much time the joint committee will take to take a decision?
This was forwarded on 26/2.
But and this matter is not for the 2024, my lord. Also matter is also not very much.
Maybe Mr. Talukdar. So you obtain instruction that when the joint committee will take a decision.
My lord.
We'll take it at 2 p.m. In the meantime, you obtain instruction that when the committee is going to settle the matter. Or Mr. Khan, you want to dispose of the petition?
No, lordship, again, this poor litigant, lordship, again, he has to come with contempt petition. My lord, this is already the third litigation.
Third litigation,
litigation.
third round.
Second round.
No, one contempt.
Okay, Mr. Talukdar, you obtain instruction.
My lord.
Timing item 3 for motion.
Maybe, under the petitioner, petitioners are two brothers and will have plaintiff, respondent here will have is the plaintiff, file it should be the English stance will have. For a plot of land, measuring will have 8 lesser. Bag number so, what number so. And 4 is he needs some share of partition on that land. Actually, the fact is this will not, our father will not purchased land in 1972 and father is a pro forma dependent, not the principal man. We are made the principal dependent. Well, yes, principal dependent. So we file a petition under order 15, rule 3, that a preliminary issue may be framed whether we are necessary parties or not. But that matter has been without going to the merit of the case, the sum has been dismissed.
No, the learned trial court in the impugn order has observed that you are occupying the land.
No, father, everything is father. Father is alive, Lord. And he purchased in 1972. He has constructed land, Lord. There is some houses, Lord, no doubt. And father name is there.
So the allegation is that the defendant, the petitioners, disposes the plaintiff opposite party from the suit land.
No, that is
so are not you necessary party? You tell me.
Actually, my father is there, land is in his name. We are nowhere to the land, Lord. There is a allegation, Lord. There should be some evidence or etc. which is taken. And then Lord, he is to decide the matter, my Lord.
Okay, let notice go. We will hear the other side.
My Lord.
Heard Mr. A. Rashid, learned counsel for the petitioner. Order dated 3/10/2024, passed by the learned Civil Judge Junior Division number 2, Nalbari. In Measure case number 109 of 2023, arising out of title suit number 47 of 2023, is challenged in this petition under Article 227 of the Constitution of India. Read with Section 151 of the Code of Civil Procedure. The learned counsel for the petitioner submits that the petitioners have been arraigned as defendant by the plaintiff in title suit number
Yes, no, 4723.
47 of 2023, and that the petitioners are no way involved in the aforementioned suit, and therefore on receipt of notice from the court they have filed a petition being petition number 1327 of 2024 under order 15 rule 3 read with section 151 CPC for framing a preliminary issue as to whether they are necessary party or not to the said title suit. But the learned trial court, after hearing both the parties, dismissed the same on the ground that the defendant struck the petitioners, disposes the plaintiff opposite party from the suit line. Mr. Rosid, learned counsel for the petitioner, submits that the petitioners are brothers and their father is alive, who had purchased the land in the year 1972.
By registered selling union, I have no particulars.
Not necessary.
And he is possessing and occupying the land.
And since then, he has been possessing and occupying the said suit land. And as such, the impugned order is illegal and arbitrary, and therefore it is contended to set the same aside. The submission so advanced by Mr. Rosid need further consideration. Let notice be issued to the respondent addresses this, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Thus, this service is also permitted. Place the matter after 3 weeks.
In the meantime, cases speaks for Milord WS. We have filed WS Milord, and my father also filed WS separately. As he is the defendant Milord.
The interim pair of the petitioner will be considered on next date after appearance of the opposite party.
Coming item 38.
We have another similar repetition in connection with this present case lawsuit. So like lawsuit, in that case, they have filed an affidavit. That affidavit will cover the same case because in earlier litigation, both the petitioners filed the common petition. Now there are two separate petitions. Your lordship may fix this matter along with WBC number 3035/2023.
Or Mr. M. Khan, learned counsel for the petitioner. Sir Khan submits that in connection with same subject matter, another writ petition being WPC number
3035/2023
is pending before this court. And in the said petition, the respondent authorities have filed their affidavit in opposition. And the said affidavit in opposition will also cover the present case. And therefore, Mr. Khan contended that this matter may be tagged with WPC number so and so. Where is accordingly allowed, recessal list the matter along with WPC number so and so on
immediate lordship.
Any
9th December.
My lord, in item 16, my lord, I have just now telephonic instruction received, my lord. As per my instruction, my lord, within 15 days, my lord, the joint committee will sit, my lord. Because, my lord, the joint committee will continuously not sit, my lord. They have stated that within 15 days, joint committee will sit, and accordingly they will pass order, my lord.
So I pray for after 15 days. or-
After 15 days, okay. Heard Mr. M. Khan, learned counsel for the petitioner, and Mr. Talukdar, learned standing counsel for the respondent number 1,
1 to 4.
3, 4, 5, and 8.
My lord.
Anybody for finance department?
Pinayak
Nayak was there.
was there.
And Mr. P. Nayok, learned standing counsel for the respondent number 2. Mr. Talukdar submits that as per his instruction, the joint committee will be sitting within a period of 15 days from today. And therefore, Mr. Talukdar contended that this matter may be listed after 15 days. There is accordingly allowed, Registry shall list the matter on date of the hearing. After 15 days, the last part of third week of December.
मतलब 10th or 12th possible.
No.
On 20th December, 20. Item 14.
I was on leg in court number 2. my lord. So it was.
This side.
You are for the petitioner?
No, my lord, I was for the respondent. It was fixed at 2 o'clock, my lord. So
14, item 14.
item 14, my lord.
Petitioner doesn't.
Petitioner nothing.
Item 14, my lord.
Age overall, time.
Actually, my lordship, I am, as per the advertisement, I have given the appointment, my lord. So due to pendency, I have the apprehension that if this writ petition is not disposed of, my lordship, so my contract may not be renewal. my lord. Agreement for the appointment may not be renewed, my lordship. That is my apprehension. So any short date may be fixed, my lordship. So.
Later the date.
On 11th December.
11. Highly agree.
Kita real. Okay.
Mr. Kyari is on legs in court number 40. So today it will be difficult.
What time?
On the same ground.
As per his convenience, today's date is fixed, lordship.
You can fix it tomorrow at 2.
Mr. Your good name?
A. Jain.
A?
A. Jain.
A. Zain, learned counsel, appearing on behalf of Mr. S.C. Kyle, learned standing counsel for the NCB, submits that Mr. Kyle is in court number
1.
Court number 1. And as such, price for listing the matter tomorrow at 2 p.m. Miss
SK Nargis,
learned counsel for the petitioner, submits that this is the 4th time the counsel for the NCB has taken adjournment. However, considering all the facts and circumstances, fair is allowed, list the matter tomorrow at 2 p.m. It is provided that no further adjournment will be granted to the learned standing counsel for the NCB.
Much obliged.
Item 39.
Lordship, same prayer.
Same pair.
Same prayer.
Okay, same order.
Much obliged.
Timing item 19.
Your lordship has put a query that charges are framed whether after that bail was granted or not, and whether that can be granted or not. Here in this case, lordship, I have just handed over one copy of our division constitution bench, lordship, 3 judges bench. Here it is that two views were there of division bench. One said, lordship, that after framing of charge, bail cannot be considered. And another division bench.
No, this issue has already been settled by Supreme Court.
Yes. And your lordship also granted page 105, lordship may kindly see, of my petition. Your lordship granted bail to the co-accused persons after framing of charge. in the present case also, who is, even the prime accused also was.
No, in that case, they have satisfied the requirement of section 45D.
45.
Now, my question is whether you have been able to satisfy the requirement of said section.
Yes, Lordship may kindly see my role in the charge sheet, Lordship.
So this issue has already been settled by Supreme Court.
No. The Lordship has put a query, therefore I have placed that there. And in charge sheet, your Lordship will find my role at page 66.
So how many witnesses examined till that?
As per my instruction, we have 10 witnesses examined out of
10
56.
witnesses
19 witnesses.
examined.
19 and 20.
19 witnesses. So whether those witnesses implicated him with the offense? or not?
So far I have seen, my lord, and the main witnesses, the Caesar witnesses are, my lord, examined, my lord. Other witnesses are yet to be examined, my lord. So at this stage, my lord, so, and they said that they are present when the Caesar is taken place, my lord. And from the search sheet, my lord, if we go to the page 66, my lord, it says, my lord, that he was also a member of the, my lord, band organization, my lord. He has
This search sheet, whether the allegation made in the search sheet are substantiated or not. That is the question.
Yes, my lord. That part, my lord, since all the witnesses are not over, my lord, at this stage, my lord.
No, till the witnesses examined till today,
Yes.
whether they have implicated him with the offense or not,
My lord, yes,
with the charges.
I have seen, my lord, the Caesar witnesses are, my lord, all the other Caesar witnesses, where the in respect to others in page, Lordship may see PW 1314, my lord. From them also some Caesar is made, my lord, that has they have implicated.
Implicated.
That the Caesar is from that person, this petitioner's man. 13. I have flag marked, my lord. My lord, from the, if I kindly allow, my lord, from the page 66, the findings that has been incorporated in the search sheet, my lord, it, my lord, clearly speaks about the involvement of the accused petitioners with the band organizations, and my lordship, as per section 43D, my lord, prima facie satisfaction may be, the lordship may record that they are, my lord, involved, my lord.
At the same time, Lordship may kindly see that this is the second FIR. Because first FIR was transferred to NIA, Lordship. And in that case, already for being member of that, already he has a sentence, Lordship. Whether for that, subsequently he can lodge the present FIR or not. Because he have to intimate to the state or central, Lordship, for the, if he receives subsequent information. In the present case, probably that was not there. He independently lost the case and lodged this second FIR, Lordship. First, if I may hand over the charge sheet copy of the NIA case, Lordship. Allegations are same. Last second page, Lordship may kindly see that there is a symbol, Lordship, that document, Lordship. Last second page, this is the sanction letter. And here in serial number 2, your Lordship will find that the first case was transferred to NIA by the order dated 21/3/2022. So once it is transferred to NIA, the informant have no jurisdiction to investigate the case. And if he receive any information, he have to transmit it to the authority concerned.
You were referring to page number?
Last second page, Annexure D of the. first
Annexure
article.
B,
The Annexure D,
last second page.
yes.
Yes.
Last third page, okay, last third page, I'm sorry.
Yes.
Second paragraph, middle portion, your lordship will find, and whereas.
Ah,
Keeping in view the gravity of the offense, the case was entrusted to NIA by this ministry's order dated 31/3/2022. So that Borpeta PS case, which the informant is saying he was investigating and then he came to know and lost the present case, that was already transferred on 21/3/2022. On same set of allegations, lordship. That he was a member of ABT. And accordingly, procedural sanction was granted, he was tried, he was lordship convicted for the period undergone. And this is the second FIR. And he did not inform as per section 6 about the present case, lordship.
yes, Mr. Goswami, have you gone through the earlier FIR and the present FIR?
And in fact, in the order which is passed by the special NIA court, lordship, that your lordship will find page 84, the roles which are implicated at page 87, your lordship will get. That is similar to present case, lordship. Page 87, paragraph 14.
Page 87
Lordship.
of your petition.
Lordship.
Paragraph number?
14. 1-4.
Mr. Goswami, have you gone through this?
This aspect, my lord, I have not gone through, my lord.
This is the same allegation as your lordship will find page 66 and 67 of the charge sheet. Present case, charge sheet in present case.
Okay, you go through it, you answer it by
Lordship.
tomorrow at 2 p.m.
Tomorrow, my lord, some cases of, can it be on Friday if the lordship permit, my lord?
Friday, cover it in cases.
I'll look at next week, you have to be there also permit.
Friday?
22nd.
Heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. Goswami, learned additional PP for the state respondent. Mr. Ahmed, learned counsel for the petitioner, submits that in connection with the same incident, 2 cases were registered by the Borpeta Police Station. Borpeta Police Station? Borpeta Police Station being Borpeta PS case number?
Borpeta PS case number 268/2022.
268 of 2022, and the other one?
Present case, that is Borpeta PS case number 763/2022.
763 of 2023.
22.
2022,
Yes.
and that the first case being Borpeta PS case number so-and-so has already been transferred to the court of, transferred to NIA for investigation. And in the said case, NIA has already filed search sheet
And concluded trial against
and in the said case, trial has already been concluded and the
Against the
petitioner, against the petitioner, and he was convicted and sentenced to undergo what was the period?
A period already undergone, Lordship. That your Lordship will find page 91.
And sentenced to undergo, sentenced to suffer imprisonment for the period which he had already undergone. Already undergone. And that subsequent case has been registered on the same facts. And as the earlier case was transferred to NIA,
Yes.
the IO has no jurisdiction. The officer in charge, Borpeta PS, has no jurisdiction to register the second case, and he ought to have referred the matter to government. But instead of doing the same, he had investigated the case and submitted charge sheet against the present petitioner. And the accused is behind the bar for how many days?
2 years, 3 months, 24 days.
2 years, 3 months, 24 days. And therefore, Mr. Ahmed contended to allow this petition. At this stage, Mr. Goswami, learned additional PP, has tried for listing the matter on Friday so as to enable him to answer, to respond to the submission so advanced by Mr. Ahmed, learned counsel for the petition. Here is accordingly allowed. Rest shall list the matter on Friday.
And on other aspect, I have paid for well, that is Lordship that from page 105 onwards, your Lordship will find that other co-accused persons who have allegation that I was in contact with them. They are also granted bail after framing of charge by your Lordship.
Okay, on Friday you will point it out.
For my friend, Lordship, I have just
Yes, I have
because he
seen.
was not there.
Okay.
I have seen
Problem.
only one aspect.
Coming item 40.
Please, Lordship.
Okay.
I was moving from there to here.
Acha,
It's
okay.
I'm okay. No, you couldn't. Do you go to this? Lordship was on whether Baldev Singh, the issue which has been laid down in Baldev Singh regarding violation of Section 50 will render a conviction to be set aside is to be applied in case of bail. Now, Lordship, I've gone through Baldev Singh's constitutional judgment in Baldev Singh's case. That issue did not arise, whether it is applicable in case of bail applications or not. All Baldev Singh says in paragraph 32 is that where the question whether or not the safeguards provided in Section 50 were observed would have, however, to be determined by the court on the basis of evidence led at the trial, and finding on that issue one way or the other would be relevant for recording an order of conviction or acquittal. So, whether there has been a violation of Section 50 or not, that has to be determined. That determination has to be made at the time of trial. That is what Baldev Singh says. So, in my humble submission, as it is in this trial, that determination has come. Of course, the judicial view has not come, but the evidence that has been laid so far, the prosecution evidence which has been laid, from there it is clear that there is a violation of the conditions which has been prescribed in Section 50. And Baldev Singh clearly lays down that if there is a violation of Section 50, then it will render a conviction to be set aside. So, in general Lordship, when bail applications are considered, if the issues grievances which are made out, if that can lead to the view that the accused is liable to be acquitted in case of even the trial which is going on, probably Lordship that and this is apparent here, from the evidence. So that can be applied for releasing the accused on bail because of the violation of section 50. Because on otherwise also, even if the trial is left to be completed, it is clear that there is a violation of section 50. So the trial court also would have to apply Baldev Singh and acquit the accused here. And one more issue, Lordship had pointed out, section 52A. Probably, why your Lordship had referred to 52A is because in case there appears to be some illicit material which has been recovered. Whether legally or illegally from the accused person. That is what is said by the alleged by the accused person. Now, Baldev Singh also says that if in violation of section 50, any material that has been recovered, that will not be admissible in evidence. So even if 50 goes, if 50 is, if we can satisfy, if the defense satisfies that there is a clear violation of section 50, then even 52A Lordship will not, we need not go into whether 52A has been complied or not, in my humble submission, because it is not admissible in evidence.
The thing is that while the trial court will prepare the judgment, he also consider all those aspects.
No, but
Only
here,
because 42 has not been complied with, and therefore he has to acquit the same. That is not the proposition. He has to consider the other aspects also.
but yes, he will consider all the aspects which forms the evidence which has come out from the evidence. Of course, that is what the trial court's job is to do while preparing the judgment. But only if the others are complied, even 42 is complied and others are complied, there is a clear authority. But if 50 goes, if there is violation of 50, that is what Baldev Singh purports to say. That is the clear proposition which has been laid down by Baldev Singh. It will result in acquittal. Conviction.
There is no dispute on that point.
Yes.
If it is not complied with, then definitely the case will go.
Yes.
The question is when this proposition is to be applied. At the end of the trial or at the consideration of bail application?
Baldev Singh does not say.
There is no proposition, no, there is no doubt that it can be considered at the end of the trial by the trial court. But whether we can apply the same at the time of consideration of bail or not. That is the question before this court.
Yes, that is what I'm trying to submit, because Baldev Singh says that how it is to be determined whether there is a compliance of 50, whether there is a compliance of section 50 or not. All Baldev Singh says that will be determined only on the evidence laid at the trial. Now that evidence is before us. And here we have a bail application pending before us, where the accused is facing trial while being under custody. Now, while considering the bail application, of course, even if in the cause title we don't refer to Article 21, even that has to be considered by the Honorable High Court. That has to be balanced. Here there is a clear, the record clearly shows that there is a violation of 50, and so even if the evidence is left to be completed, the entire trial is left to be completed, the acquittal, or there is a probability, there's a clear probability that the accused will be acquitted and he cannot be convicted. So another 6 months or 1 year, whether it will be fair to leave the accused behind the bars for another 6 months or 1 year, because that will be the minimum time that will be required to finish up the trial. Because there are 3 more prosecution witnesses left to be examined. After that, your Lordship knows what is the process, argument, etc. 313 examination, everything is left. So a minimum of 1 year is still left. So whether it will be fair for the accused to be behind the bars when there is clear evidence here. Because Baldev Singh only says that determination has to come from the evidence laid at the trial. That is only one. That issue was not before the Constitution bench or in any other case. Whether the bail, for purpose of the bail applications, that violation of section 50, but has to be taken into not. But that proposition, of course, has not been decided at Baldev Singh. But taking into account the other bail, how the other bail applications are
Perhaps
decided.
one decision of Supreme Court is there in Sareza Banu case. Sareza or Sareza like that. One case is there. Can you find it out? Sareza Banu. In one of the application, one advocate from UP has referred that decision. Can you try to find out it?
Sareja Banu.
Sareza Banu. Yes, Mr. Goswami, have you gone through the
regarding
evidence?
Yes, madam. Regarding madam, yes, madam. The section 50 it is required to be complied with, madam. That is there. And first submission will be that, madam, since 7 witnesses have already been, madam, examined, madam. So it is in the fag end of the trial. As per learned friend has said, madam, there is also question of Article 21, madam. Prolonged incarceration.
No. How many witnesses are left to be examined?
Madam, three. So at this stage, my lord, the Article 21 may not come because the trial is proceeding, my lord, and they are not unnecessarily, my lord, put behind the bars, my lord. But in some cases where the lordship has found, my lord, the Supreme Court has allowed to go on bail for long incarceration, my lord, because there my trial has not taken place, my lord. But here, my lord, now the trial is about to finish, my lord, because with in due course, in due case, my lord. So that is one aspect. So lordship may not at this stage, my lord. Lordship may not.
If the evidence brought on record so far indicates that you have not complied with the provision of those 42, section 42.
Yes, I am also coming to that. My first submission is that, my lord, the lordship may at this stage may not interfere with the evidences, my lord. That because the end of the trial, my lord. Otherwise, my lord, if a lordship will give a finding regarding the non-compliance of 50, my lord, or any other section, it may have a bearing on the trial, my lord. That is one my submission. Subject to
My finding will be on the basis of materials available on the record.
Yes, subject to correction, my lord. My first submission. Secondly, my lord, my learned friend is saying that the section 50 has been violated, my lord. But how it is violated, my lord? First, my lord, lordship may, my learned friend may discuss, my lord, so that I can give a reply, my lord, why it is, how it is violated or not, my lord. They only say that it is violated, my lord, because as per lordship will find from the FIR, my lord, my second submission is that, my lord, section 50 will not be applicable in this case.
So from where the contraband substances were recovered?
Yes,
from
that
his
is-
person or from
From the bags he is carrying.
No. Person.
Because-
Person.
Yes, from him, it is from the bag, 2 bags, my lord. Because it is a whole of, my lord, 20 kg of, more than 20 kg of ganja, my lord. It cannot be kept in a pocket, my lord. So it is in 2 bags. It has come out from it. But in that case, my lord, section 50, first, my lord, it was held that even the bags in decisions earlier, my lord, it is only held that the bags, if it is belongs to the petitioner, that will come under the purview. of
from
section-
which place it was recovered?
Section 50.
Was it a
is
public place?
Public place. It is a public place.
Yes.
It is a public.
It is a bus stand or road?
No, my lord, he is
Forest area.
It is a,
Forest
my
area.
lord, a public place, my lord. Yes,
Forest area. Lordship, at the
Uh,
night, he was, he's a villager. He went out
think
to
he
attend
proceed
to
from the
nature's call,
traveler-
and he was picked up and
After
thereby
a-
he is implicated. That is how it was
We
done.
proceeded from the person. Yes, it's a public placement.
Forest area,
I called few colleagues and also them with me.
forest reserve.
So in that case, my lord, the search and seizure may not come in the purview of the section 59. Because
Why?
now it is being held as, my lord. If the bags they were carrying, my lord, were not found from his, my lord, possession, my lord, search here, my lord, it is very clear, my lord, whether the contraband has been seized from his body or from his, my lord, belongings, my lord. Now he was found from his bag, 2 bags he is carrying, my lord. Now slightly, my lord, earlier it was, yes, my lord, they were coming for view of 50, but now, my lordship, it is made it clear that if he is, my lord, carrying the bags, my lord, if he is from the belonging, then it will not come within the purview of section 50. There are decisions to the.
Show the decision.
Yes.
Lordship, I've got Sarija Banu's decision. This was with regard to violation of section 42. Here. 42 was,
Section 50.
no, here, no, he, Lordship is trying to bring the analogy. Section 42 was not complied with, and it was held that it was mandatory. On that ground, bail was granted for violation of section 42. So in our case, section 50, difference is section 50. So if violation of section, even compliance of section 42 is mandatory. So when there was no compliance of section 42, bail was granted on that ground. Bail was rejected by the High Court, then Honorable Apex Court granted the bail. I'm trying to find. And this was a case where trial was at that time not complete. This was the case. And it was objected also that at this stage it should not be considered whether whether there is violation of 42 or not. But the Honorable Apex Court granted the bail on the ground that 42 is mandatory, and there is, if it is clear that there is a violation of 42, then bail ought to be given. So it's the same analogy can be applied in our case also.
Mr. Goswami, you show the judgment.
Lordship, just trying to find.
Citation to Kovasan. The citation of Sarija Mani is 2004 12 SCC, page 266.
2004
12 SCC 266. Sarija Ban alias Janarthani Janar versus State Crew Inspector of Police.
That specifically pointing on that, my lord. I'm certain I not, you can lordship may grant me sometime I can produce the judgment. It was searched to body and because next separate to
Oh, yeah. He took the judgment of
yes, madam. If earlier it was, my lord, the law is that, my lord, if it belongs to the, if the person is, my lord, searched, even his, if his bag is there, my lord, that will come in the purview, my lord. Now some change.
No. That proposition, there is no change. If a bag is searched, obviously, violation 50 will not be applicable when the bag is searched. When the bag and the person are both searched, then with regard to the person, 50 will be applicable. 2009 or judgment was
Person searched, please.
yes,
Where the as per the my lord, seizure, it was and witnesses, my lord, it was carried to different bags, my lord. But if my learned friend admits that it will not, that if bag it will not come within the section 50, my lord, then the position is clear, my lord, because as per the evidence, my lord, he was carrying it with the 2 bags, my lord.
So you saw the judgment?
Yes, yes.
Well, take it up tomorrow then, madam.
Yes.
Lordship, here in the evidence of the PW1, he clearly says it's in particular আছে অনিল পেগুক আটক কৰাৰ পিছত তেওঁৰ পৰা সন্দেহযুক্ত গাঞ্জা উদ্ধাৰ কৰা হয় গাঞ্জাখিনি সাক্ষীৰ সাক্ষাতত জব্দ কৰা হয় আৰু উদ্ধাৰ হোৱা গাঞ্জাৰ পৰিমাণ 20 কেজি 765 গ্ৰাম পোৱা যায় there is no mention of bags here গাঞ্জাসমূহ জব্দথলীত সাক্ষী আবু বকৰ সিদ্দিক ফখৰুদ্দিন আহমেদ আৰু আতিকুল ইছলাম থানাৰ সাক্ষাতত সিল কৰা হয় there is no mention of bags here PW1 the person who had searched the person of Anil Pegu and arrested him I can read out from the beginning itself Jua ইংৰাজী 20/11/2023 তাৰিখে মই বঙালমাৰা আৰক্ষী চকীত ইনচাৰ্জ হিচাপে কৰ্মৰত আছিলো উক্ত দিনা ৰাতি 9:30 মান বজাত হাবিলদাৰ বাবুল পালেং ফোন যোগে জনাই যে বৃহৎ পৰিমাণৰ গাঞ্জা লৈ ধুনাগুৰি মিচিং গাঁৱৰ পৰা এজন লোকে লৈ আহিছে আৰু সোণাপুৰৰ পিনে এখন বাইকেৰে তেতিয়া মই বঙালমাৰা আৰক্ষী চকীৰ দৈনিক পঞ্জীয়ন নম্বৰ 356 dated 2011-23 ৰুজু দিওঁ আৰু বিপুৰীয়া থানাৰ প্ৰভাৰী বিষয়া আৰু এডিশনেল SP লখিমপুৰ ক্ৰাইমক ফোন যোগে মই পোৱা খবৰটোৰ বিষয়ে জনাও তাৰ পিছত খবৰ পাই OC বিপুৰীয়াৰ বঙালমৰা আৰক্ষী চকীত আহি মোক অথৰিটি লেটাৰ দিয়াত মই অথৰিটি লেটাৰখন লৈ 1 নম্বৰ অধাগুৰি ফৰেষ্ট কেম্প পাভৰ ৰিজাৰ্ভলৈ ৰাওনা দিওঁ মোৰ আৰক্ষী চকীৰ ষ্টাফসহ 1 নম্বৰ আধাগুৰি ফৰেষ্ট কেম্প পাভৰ ৰিজাৰ্ভ পাই অনিল পেগু পিতা চয়ঞ্চ গাঁও ধুনাগুৰি মিচিং গাঁও থানাত আটক কৰোঁ অনিল পেগুক আটক কৰাৰ পিছত তেওঁৰ পৰা সন্দেহযুক্ত গাঞ্জা উদ্ধাৰ কৰা হয় গাঞ্জাখিনি সাক্ষীৰ সাক্ষাতত জব্দ কৰা হয় আৰু উদ্ধাৰ হোৱা গাঞ্জাৰ পৰিমাণ 20 কেজি 765 গ্ৰাম পোৱা হয় আসামী অনিল পেগুৰ পৰা এটা ৰিয়েলমি মোবাইল ফোন আৰু ৰঙা আৰু কলা ৰঙৰ এখন TVS বাইক পঞ্জীয়ন নম্বৰ 14 খন জব্দ কৰা হয় গাঞ্জাসমূহ জব্দস্থলীত সাক্ষী আবু বকৰ সিদ্দিকী ফখৰুদ্দিন আহমেদ আৰু অতিকুল ইছলাম থানাৰ সাক্ষাতত সিল কৰা হয় আটক কৰা আসামী অনিল পেগু আৰু জব্দকৃত সন্দেহযুক্ত গাঞ্জা আৰু অন্য সামগ্ৰীসহ বিপুৰীয়া থানাত ৰাওনা হওঁ আৰু বিপুৰীয়া থানাত আহি জব্দকৃত সামগ্ৰীসমূহ OC বিপুৰীয়াক জমা দিওঁ আৰু 21/11/2023 তাৰিখে মই এই ঘটনা লৈ এখন লিখিত এজেহাৰ OC বিপুৰীয়া ওচৰত দাখিল কৰোঁ আৰু এই গোচৰৰ লগতে জড়িত থকা সকলো কাগজ পত্ৰ OC বিপুৰীয়াক সমজাই দিওঁ there is no mention of bags here from the person
No,
of
madam,
the
in this seizure list, it is mentioned that 2 suspected ganja covering in a transparent plastic tape. And in one red color TVS bike bearing registration number, so and so.
Bike is lordship, the person of the accused was searched. There is no mention of bags here, that he was carrying bags. This is his evidence under oath, statement under oath. And there is no mention that the accused was carrying the contraband in bags, and and the accused in person as well as the bags were being searched. There is no mention of that here. He simply says that moi teok atok koru. That is what is stated. And he clearly says, Onil Peguk atok koru pisot teo pura hondejukto ganja uddhar kora hoy. He does not say that there were bags that were recovered from the accused person, and in the bags there was the contraband item.
It has been mentioned in the seizure list.
From there, I am submitting.
Anything can be mentioned in the seizure list, but in his evidence, the person who had conducted
Evidence, it is stated that in one bike, the person is coming with the contraband substances.
No, yes, he says that he mentions the bike number.
This para number 2 of the evidence.
Yes, উক্ত দিনা ৰাতি 9:30 বজাত হাবিলদাৰ বাবুল পলায়নে ফোনযোগে জনাই যে বৃহৎ পৰিমাণৰ গাঁজা লৈ ধনাগুৰি মিচিংগাঁৱৰ পৰা এজন লোকে আহি সোণাপুৰৰ পিনে এখন বাইকেৰে. That is what he says. Thereafter, bike number is mentioned. Yes. এক number আধাগুৰি forest agreement. In only para number 6 he says, Onil Peguk atok korar pisot teo pura hondejukto ganja uddhar kora hoy. Ganja khini hakhi hakhatot jobdo kora hoy aru uddhar hua ganja poriman 20 kg 265 gram poa jay. He does not say anything regarding mention whether it was in the bike. From these evidence examination in chief, what comes out is that from the person was searched, and from the person the contraband material was recovered. That is clear. And he does not even say, here he says that he got the information that Ezon Manu bikere ahe. He does not say that he found the accused while he was stopping the bike, whether he was on the bike, does not say anything. And he is a police officer, not just any layman. He has to be very specific because he conducted the search. We have to see who is giving the evidence.
Okay, let him clarify the position. So whether section 50 will attract here or not. You produce the relevant judgment, we will say tomorrow.
Can it be permitted in the second half?
Second half. All right. Part Ms. D. Bargohai, learned counsel for the petitioner, and also heard Mr. Goswami, learned additional PP for the state respondent, Mr. Goswami. Press for listing the matter tomorrow at 2 p.m. so as to enable him to produce a decision of the Honorable Supreme Court in respect of attracting section 50 or not in this.
May I just make one submission? If today also we have seen that your lordship had finished up the list in the first half itself. If that is the position, can we do it in the first half itself? If your lordship finishes up the list in the first half itself, after the list gets exhausted, can we do it in the first half itself instead of waiting till 2 p.m. That is, I was just wondering.
I will try my best.
If it's convenient for the honorable court.
I'll try my best.
Not 2 p.m. then.
Yeah. Sometimes, my lord, if I
at the end of the list, lordship.
Today,
At the end of
At the end of the list.
Yes, some problem arises because of the today, my lord. That is why I am taking a safer.
All right.
Any item 20.
Item 20, my lord, regarding notice, my lord, I have contacted the IO man. He said that notices were served to the informant, but my lord,
Produce the report.
Yes, I will produce the report. That report
Tomorrow?
A document.
You obtain it by WhatsApp?
Yeah, tomorrow, my lord, day after tomorrow also, you will see this fixed case, my lord. Can you be on day after tomorrow, my lord?
Today we,
After tomorrow, my lord, I'm not available up to 25, my lord.
CD is available here,
yes, my lord, say scan copy.
scan copy.
Scan copy, 25, my lord.
So tomorrow then I produce the
I'll-
WhatsApp here.
Yes, I'll produce, I'll send.
Heard Mr. Jailoskar,
Jealous from.
learned counsel for the applicant, and Mr. Goswami, learned additional PP for the state respondent. Mr. Goswami submits that as per his information, notice was served upon the respondent, but he could not produce the report and press for listing the matter tomorrow so as to enable him to produce the report before this court. Pair allowed to list the matter tomorrow.
Timing
Obliged.
23 for hearing under order 41, rule to CPC.
Like.
Yes.
May I please, your lordship, prior to my submission, my lord, the lordship may kindly accept my apologies, my lord. I could
No
not
problem, you go on.
appear in the first part, my lord.
Mm.
My lord. My lord, in this regular second appeal, my lord, the appellant has, appellant who is the plaintiff, my lord, has challenged the concurrent finding by both the trial court as well as the first appellate court, my lord. Here what happened, my lord? According to the plaintiff, my lord, the defendant has encroached upon Schedule B land, my lord. And both the trial court as well as the first appellate court came into the conclusion that the Schedule B land actually covers under DAG number 24, not under DAG number 93, which is under the possession of plaintiff, my lord. Here in this regard, my lord, both the trial court as well as first appellate court relied upon a report submitted by the circle officer, my lord, which is annexer A by the defendant, my lord. And said document has not been exhibited, my lord. So as per, my lord, provisions of law, my lord, as per order 13 rule 4, my lord, every admitted document is required to be exhibited, and my lord, by the provision of order 13 rule 4, my lord.
So have you enclosed the plaint here?
Yes, my lord.
Page number?
Plaint starts from, my lord, page number, my lord, 10.
Page number 10.
My lord.
So where is the schedule?
Schedule at page 15, my lord.
1-5.
1-5, my lord. Now, my lord, schedule A, 5 bigger 2 kata 0 lessons covered by DAG number 93, pertaining periodic patta number 8, my lord. This is schedule A, my lord. And schedule B, which is the shoot land, my lord. A plot of land measuring 5 lessons approximate out of schedule A land covered by DAG number 93, my lord.
So dispute is regarding only 5 lessons of land.
5 lessons of land, my lord.
So this 5 lessons of land is part of the schedule A land. That is
Schedule A.
5 bigger 2 kata 0 lesser.
Yes, my lord. Now, my lord, may kindly come to findings of the learned trial court, my lord.
Page number?
Is page, my lord, 32, my lord.
32.
First from page, paragraph 27, my lord. May I read it, my lord? PW1 further stated that Annexer 3 is the photograph of the day when official staff came to disconnect electricity connection of the shop room located in the suit land. And the concerned Gao Pradhan was also present there. However,
He denied that the officials of electricity department and the concerned circle officer found out on field verification that the shop rooms were located in land covered by DAG number 24, my lord. And recorded Patadar is Pelapalli Rajani Saingia, which is the wife of the defendant, my lord. According to the defendant, the shop rooms were constructed upon DAG number 24, not upon DAG number 93. In this regard, the defendant side exhibited the notice for field verification dated 29/1/2022 sent to him by the concerned circle officer Kadam Moza as Exhibit E. The defendant has also submitted field verification report dated 1/3/2022 sent by the concerned circle officer Kadam Moza to the concerned SDO APDCL as Annexer A. My lord, depending upon these two documents, my lord, the learned trial court has come to the opinion that the Schedule B actually falls within DAG number 24. Now, my lord, this Annexer A is not a part of the record, my lord, as per the provision of law, my lord. In this regard, my lord, may I place two authorities laid down by High Court, my lord? Yes, my lord. One is, my lord, by Honorable Himachal Pradesh High Court at Simla, my lord. CM Auto Stores and others versus Union of India, my lord. 1997 0 Supreme HP 390, my lord. Here, my lord, relevant portion is at paragraph 13. Your lordship has got to paragraph 13.
So, as per the plain DAG number
Schedule B covers under DAG number 93. My lord.
But as per the verification, it is 24.
It is 24, my lord. Said verification report has not been exhibited, my lord. That has not been exhibited, my lord.
The person concerned has adduced evidence who had verified the place?
No. No, my lord.
Then how the court came to the finding?
This is strange, my lord. Kindly come to, my lord, page 35, my lord. Kindly come to, my lord, page 35. Here is the appendix, my lord. Kindly see the defendant's exhibit, my lord. Exhibit A, Zamamandi, Exhibit B, Theta, Exhibit C, photograph, Exhibit D, photograph, Exhibit E, notice, which was mentioned in paragraph 28, my lord. Exhibit F, Zamamandi. That field verification report has not been exhibited, my lord. And my lord, neither the person who has issued that field verification report or notice has been examined. Now, my lord, when this issue was raised before the learned first appellate court, my lord, the first appellate court also came to the same opinion, my lord.
So the defendant has submitted the verification report
Yes, my lord.
as exhibit E.
No, my lord, that is the notice.
E is the notice,
E is the
A
notice.
is the report.
A is annexer, A is the report, my lord, not exhibit A, my lord. He has not exhibited that document, my lord.
So these are the substantial question of law you have suggested in the, but these are the grounds. Where is the substantial question of law? Come to page number 3.
Yes, my lord. My lord, 4, my lord.
4.
Yes.
But this cannot be read as substantial question of law, though you have branded it as a substantial question
Right.
of law. Hmm? You see subsection 3 to section 100 CPC.
Yes, my lord. In an appeal under the memorandum of appeal shall precisely state the substantial question of law involved in the appeal.
Where is the question?
My lord.
Though you have given one heading as substantial question of law, these are the grounds.
My lord.
Are you fulfilling the requirement of subsection 3?
Yes, my lord.
Hmm? There is also one decision of Supreme Court where it is stated that the appellant has to briefly state the substantial question of law in the memo of appeal.
My lord. It is there, but my lord, by hand we also submit sometimes. By hand we also submit, my lord. So let the matter maybe fixed tomorrow. I will submit the substantial question of law, my lord.
No, in that way it would not be possible because you have to file amended this memo of appeal, incorporating the substantial question of law. If you tomorrow you can file, no problem. I have no problem.
My lord.
Or next Monday?
Next Monday.
Next Monday?
Next Monday.
Okay. Your good name, please?
MK Sharma.
Pardon?
MK Sharma.
MK Sharma. Pardon me, sir. MK Sharma, learned counsel for the appellant. List the matter next Friday, Kobe.
Coming Friday is also 22nd, otherwise on Monday is 25th.
No. Monday, yes.
Monday 25th.
25th. List the matter on the 25th of November so as to enable Mr. Sharma to file amended memo of appeal incorporating the substantial question of law therein. You keep this judgment with you, timely. On that day you can produce it.
Yes.
And in that case, perhaps the question of law would be, can no, whether the trial court as well as first appellate courts are justified in declaring in dismissing the suit of the plaintiff on the basis of unexhibited documents. That is Exhibit A and Exhibit E. Annexer. Annexer A and Annexer E. There may be only one substantial question.
Only one.